meetings. So, yeah.
Sounds great.
Okay, we're live.
Good morning. Today is Wednesday, March 24th, 2021. We're doing something a little different right now. Our 10 o'clock meeting, it is now 10:30. We are waiting for a number of members who are tied up somewhere else right now. So I will begin by giving an introduction to a public hearing. I am Senator Susan DeChambeau of District 32. It is 32, right? I was almost going to say 34. We are, as a committee, assembled electronically today for the purposes of inviting public comment on legislation. Before we get started, I want to share some information relative to the fact that this meeting is being conducted using an electronic format. It is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the meeting via Zoom can be seen and also heard if their microphone is unmuted. People on the Zoom meeting waiting to testify cannot be seen or heard until they are called upon to speak. Before each bill is presented, I will ask the public to raise your hand if you wish to speak on the bill we are discussing. The committee clerk will start and stop the YouTube stream for the meeting. It is important to have a clear signal when we start. So I will introduce the members, have them introduce themselves. As I said, I am Senator Susan DeChambeau of District 32. I represent Biddeford, Dayton, Lyman, Alfred, Arundel, and Kennebunk Port. Representative Warren.
Thank you, Madam Chair. Good morning, everyone. I'm Representative Charlotte Warren, and I represent the city of Hollowell and the towns of Manchester and West Gardner.
Thank you. Representative Pluker.
Thank you. I'm Bill Pluker. I live in Warren, represent Hope, Appleton, and part of Union in addition to Warren, House District 95.
Thanks. And Representative Lookner.
Morning, I'm Grayson Lookner in District 37 of Portland, the neighborhoods of Stroudwater, Libbytown, Neeson's Corner, and Rosemont, not necessarily in that order.
And Representative Morales.
Good morning, everyone. My name is Victoria Morales, and I represent House District 33 in South Portland.
Representative Rickett is with us, but she just stepped aside. I will introduce our policy analyst, Jane Orbiton, who's with us right now. And also our committee clerk, Deb Fahey, is with us. And I think it is so helpful, Deb. I haven't thanked you, and I think on behalf of everybody, it's great to see the LD on your screen. So anyone on YouTube will be able to know which LD we're speaking about.
It was your good idea, Senator.
Yes, and you did it. I will give credit to Senator Curry, really. He's the one that had the idea. So I wish to continue by saying that for each bill that will be heard today, I will call upon sponsors and co-sponsors to speak first. After the presentation by sponsors and co-sponsors, I will ask if there are any legislators who wish to speak, as they may have other meetings to attend. We will then call on members of the public based on how they registered to testify. So I will call for people who are for the bill, followed by people who are against the bill, and then people who have submitted testimony neither for nor against, but they wish to provide information. I will ask you, please, to state your name, your place of residence, and the organization that you represent, if any. You will have 3 minutes to speak, and I will, when I open the meeting. So that's what we have right now, and we will wait again for other members. We do not have a quorum. When the other members appear, I will ask them to introduce themselves also. So I want to thank you for your patience. I know we've heard this for a year now when you call anybody or try to make a vaccination appointment. Thank you for your patience. So we'll wait. So.
Senator, I have heard back from Representative Pickett, and they will be here soon. They apologize for not letting us know ahead of time, but things have moved quickly on, with things they're working on. So they'll be here soon.
Okay. Mm-hmm. This must be entertaining when they watch it on YouTube, right? Lois, Representative Breckett, when the other members show up, I will call upon you to introduce yourself, okay? We just introduced ourselves.
Thank you. Yeah, I just came back from judiciary. You'd be interested to know that only one Republican was there. One of the freshman women. Everyone, all the other Republicans were not there, both Senate and House.
Apparently, yeah, I suspect this is in response to something that occurred yesterday, so.
Yeah, anyway, I just wanted to give you that information.
Thank you.
Without commentary, since I know we're on.
Did they start? Is judiciary in process?
Yeah, we just had a confirmation hearing of a judge.
Oh.
So, which we just voted on over there. I'm running back and forth between the kitchen where I can't hear you and I can hear them on my iPad, and then the computer here. It's like nuts. But sort of my version of going back and forth between the two rooms on the 4th floor. I appreciate Deb telling me that it was time for me to go over there and make sure I could vote. So, their hearings are going to start again at 11, so I have a few minutes.
Oh, we have that option. Representative Morales, you have other bills later on today to testify also?
In other committees, yes, in another
I have a
committee.
feeling everybody is backed up.
Yep.
I know, and Rachel Talbot Ross, Representative Rachel Talbot Ross has 3 bills she has to testify on, 3 different committees, so.
Victoria, which is the bill you were talking about the students testifying on?
This one.
That's LD 476, an act to provide licensed assisted living and nursing facilities level of care for incarcerated persons.
Okay, thank you.
With the way we're going, your students may be able to testify after their class.
Where are the students from? Do you know, Victoria? Are they different schools or?
I believe most of them are from Colby College.
Good. That would have been interesting for UNE also to testify. I didn't,
Right.
yeah.
If only we could had the bandwidth to reach out to everybody, right?
Have you visited Mountain View?
I have not.
Okay. Hello, Representative Pickett.
Hello.
I suspect the others will be joining us, Representative Pickett.
Yes, there's three of us here now. The other one, I believe, is going to be testifying in another committee, as I will be shortly.
Okay.
Senator, we now have a quorum, so we could get started.
Okay, I will. Representative Reckett and Representative Pickett, geez, that's a tag team. I want you to know I have conducted the intro. We've all identified ourselves. So Representative Reckett, would you present yourself, please?
Yes, my name is Lois Reckett, and I represent District 31, the ocean end of South Portland. Thank you.
Representative Pickett. You're muted. Thank you.
Thank you, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru. And I apologize for being a little tardy this morning, but we were at a press conference that was very important, not only to us, but to the people of Maine. And we felt we had to be there. Thank you very much.
Thank you. Representative Newman, would you present yourself, please?
Yes, thank you, Madam Chair. I'm Dan Newman, District 76, which is Belgrade, Rome, Vienna, Mount Vernon, Fayette, and Wayne.
Thank you. Well, we shall begin. The first bill before us is LD 476. The title is an act to provide licensed assisted living and nursing facilities levels of care for incarcerated person. The sponsor is Representative Morales, and I will ask her to present her bill.
Thank you, Senator. Senator DeChambeau, Representative Warren, and esteemed friends and colleagues serving on the Criminal Justice and Public Safety Committee. My name is Victoria Morales. I represent House District 33 in South Portland, and I'm here to present LD 476 to you today. The title of the bill is an act to provide licensed assisted living and nursing facilities level of care for incarcerated persons. In the last few weeks, we have considered several core issues in corrections: the cost of healthcare, staffing, and supervised community confinement, SCCP. This bill addresses all three of these issues. In 1976, Maine was the first state to eliminate parole. Although several other states have since eliminated or severely curtailed parole, Maine is the only state that has not only eliminated parole, but also rejected indeterminacy in sentencing. All other states without parole allow inmates to earn time off from their sentences by completing programming, learning job skills, and/or earning educational degrees. In Maine, our crime rates are declining. Arrests are down, yet our prison population continues to trend upward, with the exception of this year of COVID, when many courts were closed for extended periods, and we've heard this in committee. Longer sentences mean our prisons have a disproportionate number of the aged. Aging in prison has been the subject of extensive study in recent years. Adults aged 55 years and older grew from 3% to 10% of the total state prison population between 1993 and 2013, representing a 400% increase in number, while the median age of incarcerated adults grew from 30 to 36 years old. It is increasingly costly for correctional systems to respond to the needs of their geriatric populations, including their need for medical and mental health care. Aging inmates experience chronic illnesses and disability at younger ages than the general population, beginning at only around age 55. The estimate for the additional costs of keeping aging inmates in prison varies. One study estimated for federal inmates that cost is doubled. A study of Louisiana's cost estimated a five-fold increase from 20,000 inmate year to over 100,000 per year in 2012. Using the cost per inmate provided by the Maine DOC's hearings last week of $74,000 a year per inmate, the cost to maintain aging inmates doubled would be $148,000 per year, or if multiplied by 5, $370,000 per year. But we have an alternative. Aging is strongly correlated with desistance from criminal behavior, as seen in the Maine Department of Corrections recidivism rates by age. Current Maine Department of Corrections Policy 27.2, Supervised Community Confinement, Procedure 1, Supervised Community Confinement for a terminally ill or severely incapacitated prisoner, allows for the confinement of terminally ill inmates or inmates with a severely incapacitating medical condition in a community setting like a nursing home or a long-term care facility or a private home. While this provision was widely used in the past, it has rarely been used in the last 4 years. This policy was meant to mitigate, even if only slightly, the effects of Maine's elimination of parole. What are the savings to the state of placing the dying and incapacitated in community confinement in nursing homes, assisted living, or hospice care? Nursing home care is covered by Maine Care. You could look to the Maine Care Benefits Manual 10-144, Chapter 101, Chapter 1, Section 1.04b. That same care provided in a Maine Department of Corrections facility is not covered by Maine Care. Number 2, it would reduce transport costs. The elderly require transport to medical appointments outside the facility for specialized care, including cancer treatment, dialysis, surgery, cardiac and endocrine problems, etc. Number 3, each transport means at least 2 officers must accompany the inmate, significantly contributing to staff shortages and overtime costs. Under this policy, the SCCP policy, the patient remains in the custody of the Maine Department of Corrections and can be returned to prison either at the request of the long-term care facility or the Department of Corrections. The language in LD 476 would utilize an objective standard used by Maine Care and licensed long-term care facilities, both in Maine and nationally, to determine whether a person qualifies for long-term care. The Maine Department of Corrections facility, referred to as the Mountain View Assisted Living Unit, does not meet the community standards for long-term care. It is not licensed, and it is in violation of Maine Department of Health and Human Services Division of Licensing and Regulatory Services. A study found by the National Institute of Health and published in the International Journal of Prison Health noted these increased medical risks associated with aging are often particularly difficult to manage in the prison setting. They often go undetected and undertreated in correctional facilities, or may be unnecessarily exacerbated by conditions of confinement like shackling for transport or long-term isolation. Incarcerated elders have difficulty independently performing daily activities like eating, bathing, toileting, dressing, incontinence, and walking, and often have higher rates of depression. I will just add a personal anecdote here that I have a family member that I am caring for who is in this situation. And I can tell you that without having trained professionals who are licensed with facilities, it is almost impossible to do this work. So I ask you to support LD 476 as a means of addressing healthcare costs and staffing shortages. Doing so will improve the care of those who are dying or incapacitated and diminish the legal exposure of the Maine Department of Corrections regarding the current unlicensed facility. Thank you very much, and I'd be happy to answer questions but also you'll be hearing from folks coming after me who have worked in this system, have been incarcerated persons themselves, and also folks who work in the long-term care industry from hospice and others who will testify about this particular bill with more knowledge than I have. Thank you.
Any members wish to ask questions of Representative Morales on this bill? Seeing none? Okay. I will then ask if there are any legislators that wish to, well, not really, that's what I want to know. Are there any legislators that wish to speak on this bill? Seeing none? I will then open it up to the public. Those of you who wish to speak on this bill, please raise your hand if you haven't already, and we'll let you in.
Senator DeChambeau?
Yep.
Could you ask folks who are students and need to get to
Yes.
class to raise their hand, other folks
Thank
to
you.
take their hand down for
Yeah.
a few minutes?
Thank you. I missed that. We have a number of students, college students, who have to get to their classes, and we will like to, if others don't mind right now, we'd like to recognize the students. So would you please raise your hand so we would let you in? Okay, so I have Carissa and Faith. Okay, are you both students? Okay, so it's Alexis. So I will recognize Alexis. Please give us your question or your testimony, please.
Thank you. Hi, my name is Lexi Phillips. I'm a student at Colby College, and today I'm speaking on behalf of Jeffrey Taylor. So his testimony reads, for the past 14 years, I have been incarcerated at the Maine State Prison, and in that time, I have observed a substantial increase in older residents. Due to the increase in an aging population, medical issues are getting increasingly graver and more frequent. Even medical staff would agree that the increase in health issues is overwhelming our clinic. Having assisted and long-term nursing homes to provide qualified residents will likely prolong lives due to the higher quality medical treatment that these facilities can provide. Extending DOC residents' lives through better care in outside facilities is not only humane, it has the potential to prepare those with a chance of someday reintegrating into the community to become more proactive and more pro-social. It is also important to remember to not let one bad day or moment define a person's existence. It is our duty as contributing members to society to mentor those by demonstrating empathy and compassion. Most incarcerated individuals feel detached from their community, and a residency in an assisted living or long-term nursing environment will undoubtedly increase the feeling of being a part of a community, thus reducing the detrimental effects of isolation. It is for these reasons that I stand in strong support of LD 476. Thank you.
Thank you, Alexis. Any questions of Alexis? We shall proceed with Carissa. Carissa, are you a student?
Hello, my name is Carissa Yang. I am a current student at Colby College as well, and today I'm here to read testimony on behalf of Leo Hilton. Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice Committee, my name is Leo Hilton. I live in Maine State Prison, Warren, and I am writing to support LD 476, an act to provide assisted living and long-term nursing home care for incarcerated persons. In addition to being an incarcerated person myself, I am also a state-certified personal support specialist and MSP hospice volunteer. Over the past 7 years, I've been very blessed to provide end-of-life comfort care to many men, including some very dear friends. However, I have also witnessed great physical and existential suffering as men struggle to reckon with their dying in prison, unable to see and reconcile with family members who cannot bring themselves to enter a prison. Sadly, I have also seen it too many times when this suffering was exacerbated by feelings of living in segregation. Rather than dying in comfort and an environment of peace, They were subjected to facility countdowns, lockdowns, count times, and rotating staff who did not at all understand that dying human beings deserve to be treated with compassion. Instead, they were treated with general apathy and in some cases outright disdain, as if their dying was an inconvenience to the orderly operation of the prison. While there have been some caring and compassionate nurses who have taken wonderful care of those who live and die in the infirmary, and the hospice team remains ever ready to provide our peaceful presence there, I do not have words to convey how painful it is to hear a man wish he could die anywhere else but where he is, and to not be able to help. Incarcerated people need access to assisted living and nursing facility levels of care in licensed environments. This level of care is currently lacking. Please pass LD 476 into law. Thank you very much for hearing and considering my testimony. I pray you have heard my heart and will act accordingly. Respectfully submitted, Leo Hilton. Thank you.
Thank you. Carissa, that gentleman, his name is Leo Hilton?
Yes,
Okay,
that is correct.
good. Any questions of Ms. Yang? Seeing none, I will ask Faith, are you here to testify also?
Yes. Hi, everyone. My name is Faith. I am a student at Colby College, and I'm here today to testify on the behalf of Nathan Goodwin. His testimony reads, Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice Committee, my name is Nathan Goodwin. I reside at the Maine State Prison, and I am writing to support LD 476, an act to provide assisted living and long-term nursing home care for incarcerated persons. I have resided at the Maine State Prison since June of 2011, and I've worked as a hospice volunteer since 2015. During my time at the prison, I have come to know many of the men who reside here and who live out their final days here at the prison. In my role as hospice volunteer, I have been blessed to spend many of those final days sitting bedside with a number of dying men. This has given me a unique opportunity to see firsthand how this bill would benefit many of the men, and I am sure one day some women at MCC as they live out their final days. Many of the men I have sat with have not had any remaining family to care for them, and this bill would not change their end of life experience. The care they received at the MSP infirmary with the assistance of the hospice volunteers was the end they would have chosen if they had the option proposed in this bill. The men in this facility had become these men's surrogate family, and by living out their final days here inside the prison, they were able to receive visits by these men, their family. There have also been men with family who care about them and have navigated the hurdles necessary to visit their dying family member within a maximum security facility. The administration of the DOC, under now Commissioner Liberty's guidance, has made it as accessible as possible within the guise of a maximum security setting, but the nature of this setting will always hinder a family's ability to spend time with their loved one. The geographical locale of the prison itself makes routine visits over a short period of time both difficult and expensive. Add to this the need to time their arrival and departures around prison counts and shift changes, and the necessity of the maximum security facility to limit the visitors' access in and out of the prison. I have witnessed this lead to shortened visits as the family member ends the visit when they become hungry or need a cigarette or personal medication, which cannot be brought inside the facility. Add to these hurdles the sheer anxiety of being inside a facility of this nature, and the visits can become uncomfortable and not conducive of the quality time a family member needs as they say their goodbye. This is compounded by the difficult conversations which commonly need to be had between an incarcerated citizen and their family which was left behind at their incarceration. These conversations are not easily had when confined to a set visit period and the 15-minute checks of even the most courteous security officer. While I personally believe the usage of the outside care facility would not only be used by a small number of the men who find themselves living out their final days at MSP, the benefits those families will reap as they spend unhindered time together and have those difficult but healing conversations in an inviting and hospitable setting will far outweigh the relatively minor work needed to set this bill in motion. Warm regards, Nathan Goodwin. Thank you.
Thank you, Faith. I didn't get the first name of Mr. Goodwin.
It's Nathan.
I didn't hear that, excuse me.
Nathan?
Okay, thank you.
Yeah.
I also want to thank Mr. Goodwin and yourself for mentioning females. We were talking about the Maine State Prison a couple of times here. I will ask if anyone has any questions of our student. I will ask, because I'm curious, is this a gentleman, Mr. Goodwin, that you've been communicating with, or is this part of a school project, or, I mean, a class, I should say? I want to commend the professor or anybody who's made you or got you interested in this. Can you share with us your contacts?
Yeah, I can say a little bit, and then Lexi actually has her hand raised, so she'll be able to say something more.
Okay.
I know Lexi and I are actually participating with the Maine Drug Policy Lab at Colby,
Okay.
and a lot of the work does do with communications with current inmates, and so yeah, that's some of the work that we're getting to do, and so this opportunity arose for us to be able to testify for people that couldn't really do that for themselves. So I personally was really interested, and so that's why I jumped on the opportunity.
Thank you. Thank you very much. Someone else had their hand raised. Alexis?
Hi. I sent an individual message. I'm not sure if you had the opportunity to see it, but 3 of our fellow students who were set to be reading testimonies today did have to step out for class, and I just wanted to kind of check in and see if we would be able to read those for them or if we should just move past.
Well, we have the written testimony, so we will, let me see, I believe we do. Let me just check. Do you know the names of those individuals?
Yes, it was Eliza Anderson, or she was set to be reading Foster Bates' testimony, just a moment. And then Ketty Simpson was going to be reading James Prescott's testimony, and Terry Nwanma was set to be reading Tim Pierce's testimony.
I don't see them on the list, but if you could get that testimony to us, our clerk will make sure we get to read those testimonies, all right?
Okay,
I don't see them on the list. Thank you. Carissa, you have a comment to make, a question?
Yes, I am also a student at Colby, and so I heard about this opportunity through my professor. Last semester, I took a course on cultural anthropology, and our specific focus was on abolition and care versus harm and crime. And so when I heard the opportunity to be volunteering with the Maine Prisoner Advocacy Coalition, I wanted to come by and offer my voice in place of Leo's to make sure that his voice is heard today in our conversation. Thank you so much.
Thank you. I really do commend those professors anyways. Representative Pluker?
Thank you, Madam Chair. I just wanted to, I work with Leo a bit, and just so we have the context of the letter he's writing, he's someone who's been incarcerated since he was 18 for the last 10 years. He's gotten his high school degree, his undergraduate degree. He's now working on his graduate degree in conflict resolution. And unless we change the laws of the state, he's likely going to be at MSP until the day he dies. So this bill, and he's doing hospice work, which is just amazing. And I don't know, we mentioned that Foster Bates had some testimony. I don't know if one of the students was able to read that at Foster as the president of NAACP inside. Yeah. It might be relevant to hear that in person.
I think the others are just as valuable, and we have the written, we will be getting the written testimony. We don't have it. So, and I agree with you with Mr. Hilton. I met him as a younger man, and he was probably the youngest person to do hospice care. So it's very commendable what they do.
Thank you.
Representative Warren?
Thank you, Madam Chair. I just want to give a thank you to you students for bringing those voices to us. as I'm sure you know, many of us are trying to work with the Department of Corrections so that the inmates can actually deliver their own testimony. We've been told for 7 years, at least while I've been on this committee, that we can't hear from inmates because it would be too hard to get them to the State House to deliver their testimony. And now everybody delivers testimony via Zoom. Our inmates have access to Zoom. I do some meetings with them around educational opportunities, and we're still being told that their voices shouldn't be heard at our State House. They are Mainers, they do deserve to be heard. So I just want you to know that what you did today, it really matters. I know you already know that, but I just needed to put that into words, and I thank you for being the people to deliver those voices, and pass back to the folks, please, that we're continuing to have conversations with the DOC to try to get their actual voices here. They deserve to be heard. They're Maine people. So thank you.
All right, we shall proceed, continue. Thank you again, students. Thank you all. Any other co-sponsors, and I'm sure, not co-sponsors, anyone else wish to speak in favor of this bill? If you have not raised your hand, please raise your hand and the clerk will let you in. I think the students, we're gonna make room. The students. I have Irvin Fonts. Is he on?
Yes.
Okay, let's see. Mr. Fonts, I have you. First, would you please give us your testimony?
Yes, I'd be glad to.
Thank you.
Senator Deschambault, Representative Warren, and members of the Joint Committee on Criminal Justice and Public Safety. My name is Irving Fonts. I live in Wilton. I had the satisfaction of working in long-term and assisted living facilities in Maine for over 25 years. I was a licensed multi-level long-term care administrator. I now serve as chair of the board of directors for the Maine Prisoner Advocacy Coalition and have a son who is incarcerated at Maine State Prison. During my career in long-term care, I had the opportunity to admit and coordinate care under the supervised community confinement program for incarcerated men. The first man I admitted was terminally ill. His wife lived in Farmington and our facility was in Gardner, so we were able to substantially reduce her commute. The inmate had sexual abuse on his record, and our nursing home was directly across the street from an elementary school. We met with the leadership and parents from the school who raised no concerns after they had been fully informed of the inmate's condition. Ultimately, his wife requested that he be allowed to die at home. I wrote a letter of support for the Superior Court. He was allowed to go home. The second inmate was in a full body cast due to a fall. He was languishing in the MSP infirmary where there were no social activities or people to speak with. He was in his 50s, but he settled comfortably with the older adults in our care. He socialized, played bingo with the residents, and received appropriate medical and nursing care, as well as treatment for his mental health. The third and fourth admissions were brothers who had Huntington's disease. We arranged for staff training for the care of those who have this disease. The brothers were 39 and 44. Again, they settled comfortably with the age group, socialized, and were able to have visits with family, including their children. In all of these cases, the written agreement with the Department of Corrections was that we could return these men to the prison with no questions asked. We did not have any behavioral problems with them. There were several advantages to community confinement for these men. One, they received appropriate nursing care 24 hours per day. 2, our medical director was at the facilities 2 days per week and was able to speak with and examine them and review their medical condition and clinical needs. 3, socialization with residents improved their quality of life. 4, visits by family, friends, and loved ones were encouraged and were available 7 days per week. The payment for our services was covered by Main Care. The reimbursement was roughly $3,400 per month, a substantial savings over the average inmate cost of $6,000 per month at the state prison. I urge your support of LD 476. Thank you.
Thank you, Mr. Fons. Mr. Fons, have you submitted that written testimony to us so we can make reference to it?
No, but I will.
Yes, I truly appreciate that. Thank you. Any questions of Mr. Fons? Seeing none, again, thank you. The next person I have is Anthony Lombardi, followed by Marissa Wheel. Thank you.
Senator DeChambeau, Representative Warren, and the honorable members of the Criminal Justice and Public Safety Committee, good morning. My name is Anthony Lombardi, and I'm a legal fellow at GLBTQ Legal Advocates and Defenders, New England's leading legal advocacy organization for LGBTQ rights. I'm here today to share the support of GLAAD for LD 476, and I'll note that I'm a lobbying associate of Mary Bonato, who works with GLAAD and lives in Portland. This bill is necessary to adopt Maine state prisons to the aging population they serve. By requiring the state prison system to provide for long-term care, the department would provide medically and personally necessary care to individuals and increase efficiency in facility administration. Nationally, an increasing percentage of state prison populations are comprised of people aged 55 and older. GLAAD has a vested interest in this bill due to the disproportionate number of LGBTQ individuals in the prison population, though we do not have data for the aging population among those groups. Data show that 5.5% of men in state prisons identified as gay or bisexual, 42.1% of women in state prisons were sexual minorities, and 2% of respondents in a national transgender wellness survey reported being incarcerated in the previous year. Now, these rates of incarceration far exceed the percentage of LGBTQ people in the adult population as a whole, because it's estimated that LGBTQ individuals comprise approximately 4.5% of the population in the United States. As a baseline, we all know that increasing age can bring changes in virtually every aspect of bodily function. The duty to provide appropriate medical and mental health care on an individualized basis and to accommodate a person's disabilities from aging are fundamental legal commitments in our justice system. Last, and certainly not least, passing this bill is the right thing to do. Many of us have lost parents, relatives, and siblings to health conditions, and some of us lost family members during the pandemic, whether because of COVID-19 or otherwise. As a family member of a dying person, you may be thinking, how can I support and comfort them? Are they getting what they need? Are they in pain? And what can I do about it? And finally, are they being treated like a beloved human being? Sorry about that. This bill asks us to provide the needed care for those who have to spend their final months, weeks, or days in a state prison, and as a result, to ensure they do not die alone. We thank you for this opportunity to speak today, and we urge you to vote ought to pass on LD 476.
Thank you. Any questions from Mr. Lombardi? Thank you. Thank you again. I see Mr. Payson and Ms. Reed. Do you wish to speak? If so, can you raise your hand so I can call on you in order? Okay, so I've got Marissa. Is it Marissa? Real? Go right ahead. Hi.
Thank you. My name is Marisa Weil. I live in Freedom, and I want to thank the committee chair and members of the committee for the opportunity to speak, and thanks to Jan at the Maine Prisoner Advocacy Coalition for inviting me to speak to this issue, which is very important to me. I grew up in Southwest Vermont, and I spent most of my adult life in California before moving to Maine in 2014. I have been extremely fortunate to have traveled the world and had many adventures and memorable experiences. One of the most memorable and impactful experiences of my life so far has been working in the volunteer hospice program at the Maine State Prison. I found a job with the Maine Hospice Council when I first moved to Maine. I will note for the committee that at this point it has been many years since I have been employed by or associated with the Hospice Council. I knew nothing about hospice or palliative care at the time, but I have always been inspired by jobs that give me the opportunity to take deep dives into important issues and perhaps even make a difference in the world. No doubt why all of you choose to serve our great state of Maine too. Working with the inmates at the Maine State Prison gifted me the opportunity to wrestle with difficult concepts. Is the point of prison to punish or rehabilitate? What is the right way to treat people who have done wrong? Are people more than the worst thing that they ever did? Every inmate is someone's sibling, parent, grandparent, child. Every inmate means or has meant something to someone on the outside. In a 2001 study published by the National Institute of Justice, researchers found that being abused or neglected as a child increased the likelihood of arrest as a juvenile by 59%, as an adult by 28%, and for a violent crime by 30%. Intellectually, we know that there is a cycle of violence that gets repeated and that this plays out in our criminal justice system over and over again. Abusers were very often abused themselves. I think that this is an important thing to remember when we consider how we should treat incarcerated individuals. It is easy to get caught up in the crime and the suffering of the victim, and it is easy to dehumanize the perpetrator. But I strongly believe that we should resist this instinct to dehumanize offenders and judge them only through the lens of the worst thing they ever did. The state is in charge of incarcerated individuals. We hold all the power in terms of how they live, and in many instances, how they grow old and die. When people face their end of life under conditions of incarceration or have to attempt to navigate complex challenges related to their health or abilities while incarcerated, we have a choice whether to act compassionately or not. And the choice we make reflects on us, the people on the outside and the people who are in charge of their incarcerated existence. Pearl S. Buck once wrote that our society must make it right and possible for old people not to fear the young or be deserted by them, for the test of a civilization is the way it cares for its helpless members. Incarcerated individuals are helpless, and by design, they are deserted, separated from the outside world and its inhabitants. It reflects deeply on us as a society how we treat these people who are so vulnerable and so removed from the watchful eye of the greater community. For our own psyches, our own souls, whatever you believe to be our essential humanity, I think that we owe it to ourselves to care for vulnerable incarcerated people and their healthcare needs, regardless of the crimes they have committed. And so I urge you to pass LD 476, an act to provide licensed assisted living and nursing facilities levels of care for incarcerated persons into law. This simple legislation, and I thank Representative Morales for her sponsorship of the bill, would go a long way towards proving our humanity to ourselves. Thank you.
Thank you, Ms. Will. Any questions for Ms. Will? Seeing none. I have Ms. Reed next, followed by Mr. Payson. Ms. Reed?
Greetings, Senator DeChambeau, Representative Warren, and the honorable members of the Criminal Justice and Public Safety Committee. My name is Holly Reed, and I live in Bath, Maine, and I'm here to testify in favor of LD 476. My background is that I have been a registered nurse for 34 years. I am currently employed as a home health nurse. One of the things I do in this job is care for people who are in assisted living facilities. Also, I am employed as a part-time pastor in Bath, Maine, where one of our ministries is to walk with people who experience incarceration. To this end, I am a volunteer hospice chaplain who, before COVID time, would go up to the Maine State Prison weekly to support the hospice program. From a nursing point of view, it's important that people who require an assisted living level of care live in a facility that's licensed as an assisted living. Along with licensing comes regulations and standards. And as a nurse who is heavily regulated by Medicare guidelines, I know they can make you crazy. But each regulation serves a purpose, and that is to ensure that patients receive quality, safe care. If the Department of Corrections has incarcerated people who need assisted living level of care, then it's important that these individuals reside in a licensed facility so that it can be assured that they receive safe quality care like any other Mainer who requires assisted living services. As a hospice chaplain, I recognize that dignity is an essential piece of end of life. I want to be clear that I am not criticizing the Department of Corrections. I have visited the infirmary and seen amazing care by all who work in the department. My point is that the very nature of being incarcerated does not allow full dignity to occur. For example, correctional officers, I don't believe, receive training on how to provide hospice care. I observe that they are required to be vigilant and to watch carefully every movement. They are trained to make sure people follow the rules. I think it's a lot to expect an officer to simultaneously be in a hospice frame of mind and in the role of correctional officer, and I'm not sure that it's a fair thing to ask of anyone. I feel like the current system provides a lack of dignity to the dying person and to the correctional officer. And I will also say that just because you have an RN degree doesn't mean that you have been trained as a hospice RN. Hospice is a specialty and requires additional training for the RN and for the aides. And so people who are incarcerated and at the end of life may not be receiving care by people who have been adequately trained. And so that's why I support this bill, LD 476. Thanks for hearing my testimony.
Thank you. Any questions from Ms. Reed? Seeing none. I personally want to thank you for your service, Ms. Reed, as a nurse and pastor and volunteer hospice. It's a lifetime of dedication, so thank you very much. And I'll recognize Mr. Payson. Welcome.
Thank you. Good morning. Senator DeChambeau, Representative Warren, esteemed honorable members of this committee. My name is Robert Payson. I represent MPAC and I live in Wiscasset, Maine. My story goes as follows. I've spent more than 30 years at the Maine State Prison. I went there for the first time when I was 21 years old. I am now going on 54. I was released in August 24th of last year. During my time at the prison, I was able to get a bachelor's degree. I was part of the hospice program. I was part of the second graduating class. It changed my life. I had the honor of being 6 men as they took their final breath on this earth. That was very moving to me. I learned great skills such as active listening and compassion, and all in all, it made me a better person. But hospice on the inside at the prison isn't the end-all be-all solution. As COVID has shown us, there's things that happen that interfere with the orderly functioning of the prison. Because of COVID, hospice workers have not had regular access to the men who need their services. So it's been placed on an already overworked staff of nurses. I don't think that serves to the benefit of the men that need care. Also, a lot of people have talked about the healthcare costs and the security concerns. I want to take a little different direction here. I want to talk about the attitude towards the men who are up there. We all know that the decisions that we made out here in the world put us in prison. You know, decisions I made put me there for a long time. And it's that attitude that people have towards these gentlemen that create a conflict of good health services. In the infirmary, there are officers positioned there because security comes first. I'll tell you 2 stories. The first story is a gentleman that pulled a tortured soul. He poked out his own eyes and he's strapped down to a bed and they fed him and he spit on me. I know my time's running short. So he spit on me and I smiled and I fed him again. And the officer said, you know, you're a better man than me, because if he did that to me, there'd be a problem. And the second one, a man, you know, who struggled with dementia, threw feces at me, spit on me, did other things. And I'm a big person, I'm a prideful person, and I just smiled and I helped him through it because I'm qualified to help him. But the prison has a policy when it comes to security. It's about compliance with the small asterisk, any means necessary, you know, and so it serves to the benefit of the men and women who will be undoubtedly needing this service to be in the proper places. And I believe that is a qualified, licensed, assisted living facility. So thank you for your time. I appreciate you.
Thank you. Any questions, Mr. Payson? Mr. Payson, we know each other, right?
Yeah.
And I really respect your testimony, and I know the good work you did in hospice. I'm old-fashioned when it comes to corrections, and you know that also. So I'm in my head thinking, you probably have been at the deathbed of long-termers, right?
Both. Both. I would mention this, and even though I support the bill as it stands for everybody, not everybody most of the people that pass away at that prison due to health reasons have release dates. They're not doing life sentences. They have
Correct.
release dates.
Correct. But my question is, and I want a clarification from you, long-termers, my experience has been many of them have lost their families or families are not close to them. Have you ever worked with someone, and I've had experience also, that have no one out there, and I'm questioning putting them away, and not away, but for specialized care. You're taking them away from, quote, their family. That's probably very naive of me to say that, but it's been my experience. Could you speak on that? Of
Yes.
people who don't have anybody?
Yes, there was the last man who died on my shift had lost all his family.
Yeah.
I would say this, that it would be a choice because a lot of people do have families, but there are some that don't. And those people would choose to be there with a family that, as Nate Goodwin had testified in his testimony, some people would make the choice that they'd rather stay there and get the love from their adoptive family, the people that they've known for decades. But to have that choice is everything. And I think that's what we're really talking about here, is to have that ability that those that have family to have closure on every end.
Well, you probably confirmed what my thinking, and for others to hear that it's a choice. And there are some that the family, as you said, is the prisoners, the guards, the nurses. So that's something to reflect on. Again, thank you very much, Bob. Thank you. Okay. Mr. Lerman, I see you're here. Did you wish to testify? Because I'm looking for hands and I don't see.
Senator, Mr. Erb has had his hand up. Richard Erb.
That's what I'm looking for. I can't find it. Well, go right ahead, Mr. Erb. Yep, you're muted. Okay,
Nope, right
thank
here.
you. Go right
Thank
ahead.
you. Morning, Senator DeChambeau, Representative Warren, members of the committee. My name is Vic Erb. I'm president and CEO of the Maine Healthcare Association. Our organization represents nursing homes and assisted living facilities across the state. I'm here today to testify in support of LD 476. It's well known that Maine already has one of the oldest populations in the country. Looking ahead, the number of Maine residents over age 65 will increase by 49% in the next 15 years. The Maine Alzheimer's Association tells us that there were 25,000 people in Maine suffering from Alzheimer's in 2014, but that this will increase to 35,000 by 2025. I'd like to also share a little information on Maine's system of long-term care. For the past 25 years, Maine has aggressively pursued a policy that reserves nursing home level of care for people with the highest needs. Wherever possible, people are served in their own homes. When that isn't possible, the next step in this continuum of care is assisted living. Many of the people residing in assisted living in Maine would be nursing home residents in other states. The average age in Maine's nursing home is 84, but the assisted living resident is typically only a couple of years younger. Failing to plan for the needs of this population is irresponsible, regardless of where they live. This includes Maine's prison population. LD 476 provides for assisted living and nursing home level of care within correctional facilities. It also allows the Department of Corrections to provide services in the community and would encourage licensed facilities in the community to accept prisoners. This is a critical point for my members. We believe this does not require facilities to accept prisoners, although they may choose to participate in the program. And it won't be the right fit for every facility or for every prisoner. For those that do choose it, the bill requires that specialized training be provided to the facility. I would also add that adequate rates would need to be developed, as I am certain that out of the ordinary costs would be encountered. I don't know what the cost would be to establish long-term care beds within a prison setting, or how many facilities within the communities would want to participate in a program to serve inmates. But this is an issue that deserves more study and work. Maine Healthcare Association would be pleased to be involved and to share our expertise. For this reason, I hope that the work continues through LD 476. I'm happy to answer any questions. I thought it would be helpful to give a little explanation of long-term care in Maine, so that's why I'm here. Thank you.
Very good. I think we all appreciate that, Mr. Erb. Anyone have any questions for Mr. Erb? I don't see. I trust, Mr. Erb, that you will be, if you haven't submitted that testimony in writing, there's some good information in there we would like to look at.
I'll verify that it made it, but I believe I put that in this morning, but I'll check on that.
Thank you very much.
Yep.
Okay. Excuse me, Representative Warren, do you have a question?
Thank you, Madam Chair. Mr. Erb, thank you very much for your testimony. I'm obviously interested in the ethical and moral part of this bill, but I'm very interested as well in the financial portion. So would you be able to be here for the work session? Because I think we're going to have a lot of questions about the cost to Maine taxpayers if we don't make this change.
I'll plan to be available for it, and I'll do what I can to look into it. I think, as Mr. Font said this morning, we have known of placements in years past, although not recently. So there is some history with it. But again, not recently, but I'll find out what I can.
Thank you, Mr. Erb. And I think the expansion of Maine Care really creates quite a different situation if we can be using that sort of funding. So thank you very much. I appreciate that. Thank you, Senator.
Okay. Seeing no questions, I will call upon Candace Powell, followed by Michael Cabetta. Doing better, Michael. Thank you. Hello, Ms. Powell. You are muted. If you may unmute yourself. Thank you.
Good morning, Senator DeChambeau and Representative Warren and members of the Criminal Justice and Safety Committee. I'm delighted to be here, and I've enjoyed the testimony of all the speakers this morning. Really touches my heart to see the sensitivity and caring toward those who are incarcerated, both men and women, especially those who are aging in place at the correctional facilities and looking to the future without the choices that they really need. My testimony today, as many of you know, comes from my 18 years on the ground in the prison, working with the remarkable men at the Maine State Prison, who I have spent those years with training, debriefing, counseling, just patting them on the back and congratulating them for the incredible work that they have done in the hospice program. And what I have seen as far as the potential of men at the prison is remarkable and speaks well for the options that correctional facilities have for the future. The 18 years I spent there developing the hospice program, the love, skill, sensitivity, and kindness I observed touched my heart. The changes in the men touched my soul. The rehabilitative potential for both patient and caregiver were immeasurable. And I say that by way of referring to the care that those who are aging in place have benefited from receiving over the last several years. What people need are options. There should be no double standard in access to quality health care. It should be standard across the board. And the broad policies that correctional facilities have, which sometimes do not lend themselves to the type of care that is specific to those who are aging, who may have various comorbid conditions, and who need specialized care. What we need to give people is options. LD 476 gives folks additional options. Maybe what we need to be looking at are hybrid models. Yes, we need to have the type of care within the correctional facility for those men and women who choose to remain there. As Mr. Payson said, sometimes folks do not have family, and what they need to have are the support of caring people. In the case of the Maine State Prison and the hospice program, those men whom they call their brothers are the ones that have stepped up to become their family and provide the kind of support and care that everyone needs. In addition, the care that specific care in long-term care facilities, and it's not the facility, it's the quality of the care and the emotional intelligence of the caregiver that makes the difference. But what it does is it also acts as a rehabilitative model for men who are trained to provide that care. And that's just something to think about going into the future. There are so many pros for providing the options that men and women who are aging in place really, really need. And what we need to do is develop those options. We need to interview the elderly in the prisons and those with disabilities who sometimes require the same, no matter their age, require the same attention and specificity as the elderly do. So there's a lot of work to be done in this field, and working with folks like Rick Erb and the Maine Healthcare Association in conjunction with the community, and also hearing the voices of the people who have been incarcerated will increase our knowledge base, will increase the richness of the care that is built into the planning for the future, and will adjust, hopefully, the broad policies that many people don't fit into within correctional facilities and really only serve in setting them up for failure because they can't comply with some of the rules and regulations when they have such comorbid conditions as dementias. And Rick Erb just mentioned the staggering statistics for dementia going into the future. So I know I'm out of time.
Okay.
I'm sorry.
Yeah, go ahead.
Yes, if you
Yes.
could wrap up, you're at the end of your 3 minutes. Thank you.
Sure. I just again offer my support for LD 476 and all the people that have supported in favor of it. Thank you very much for your time.
Any questions of Ms. Powell? Representative Warren, you have your hand up.
Thank you, Madam Chair. Ms. Powell, I just want to thank you for all of the work, all of those 18 years that you've done inside the Maine State Prison. And I also want to congratulate you on your recent award. Very happy to see that. So congratulations.
Oh, thank you very much.
Good to see you.
Thank you.
I echo that, Ms. Powell. I've never called you Ms. Powell, Candace. I truly appreciated the education you gave employees when we attended your conferences, yearly attended at the Maine State Prison with the public and the prisoners that were hospice workers. Truly a novel idea that worked. Thank you. Thank you.
You're very welcome.
Okay, so we are moving along and we have Michael Cabetta. Right, Michael? Gotcha.
Absolutely, Senator Shambo. You nailed
Right.
it.
Go right ahead.
I appreciate it. As someone with a not straightforward last name yourself, I'm sure you sympathize. Representative Warren and distinguished members of the committee, good morning. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine. On behalf of our members, we urge the committee to support LD 476. Maine has a relatively high percentage of elderly prisoners in the country, with at least 1 out of 10 prisoners over the age of 55. As a result of 40 years of tough on crime sentencing, our criminal justice system has undergone a gargantuan expansion, one about which your committee hears a lot about. Our nationwide prison population has almost quadrupled in 4 decades, and with it, so too has the number of elderly people in prison. Maine's prison population has more than doubled since 1983. Our jail population has grown over 6-fold since 1970. Like older people in the general population, elderly prisoners tend to be more susceptible to chronic health and medical conditions, translating to higher healthcare costs and assistance performing daily tasks of survival. The 8th Amendment to the federal Constitution since the 1960s has guaranteed all prisoners a right to healthcare while incarcerated and protects them against indifference to their serious medical needs. However, prisons are not built to accommodate an aging populace, and there are serious challenges and costs associated with providing adequate healthcare within the prison setting. Although we cannot erase the 40 years of extreme sentencing and unfair and unjust criminal justice policy, there are steps we can take to reform the system, both in the short term and in the long term. As you've heard already, in effect, some of our prisons have become assisted living facilities in all but name. But unlike accredited assisted living facilities, they're not held to the same standards of care. This bill would help solve that problem by establishing appropriate standards of care for our aging prison population, by accrediting parts of some prisons as long-term care facilities, and by requiring the Department of Corrections to collaborate with accredited long-term care facilities in caring for elderly prisoners. These reforms are common sense. They formalize current practice and would hold us to the promise of our Constitution. We urge you to vote ought to pass. I thank you for your attention, and I'm happy to try to answer questions.
Thank you. Anyone have any question for Mr. Cabetta? Seeing none, thank you very much. I now have Carla Hunt. Is Ms. Hunt here? You had your hand raised. I don't know, did our clerk?
I'm here.
Okay.
Sorry.
Have we brought you in?
Yes, I believe so.
Okay, we don't see you, but go right ahead.
My name is Carla Hunt. My address is 3 Church Street, Yarmouth, Maine. And I'm reading on behalf of Ralph Nichols, who is at Mount View Correctional Facility. Dear Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committee, My name is Ralph E. Nichols, and I have lived in the assisted living unit at Mountain View Correctional Facility for over 4 months due to a heart attack and triple bypass heart surgery. After I transferred out of ALU, I volunteered to work with individuals who lived in the ALU for 11 months until I was transferred to the minimum side of Mountain View Correctional Facility. I am writing to support LD 476, an act to provide licensed assisted living and nursing facility levels of care for incarcerated persons. LD 476 is definitely needed and long overdue. I am also attempting to get authorization from Warden Morin to allow me to talk and get testimonies from residents of the ALU. In my short time, 15 months, in being exposed to the operations of the ALU at Mountain View Correctional Facility, I have experienced several individuals who have passed from cancer and or other life-ending conditions while being alone. I have experienced how the ALU at Mountain View Correctional Facility is supposed to have a medical staff in the unit at all times, but on the average, they are only there about 6 hours of the 24 hours in a day. This is how an 80-plus-year-old gentleman's left on the cold concrete floor after he fell and hit his head. The gentleman had dementia and wandered around the unit and was considered a nuisance because he was in need of constant monitoring by the ALU staff. With no medical staff in the ALU unit checking on the resident and only having the Maine Department of Corrections staff doing bed checks for security is where things started to go wrong. I can only surmise that when the MDOC staff found the ALU resident on the floor, he thought, he is sleeping and not bothering anyone. All is good. Another gentleman who was diagnosed with life-ending cancer was transferred to ALU only to pass on without ever being allowed any visitors in ALU, per policy. He was physically unable to go to the visits room, so he died alone. This facility also does not even have a hospice program. He was also within 6 months of being released, which is so disappointing that he had to go through that alone, no family or friends. I believe that LD 476 will require that MDOC make changes to the current practices of caring for ALU residents in a very positive way. Thank you for your consideration. Sincerely, Ralph E. Nichols, number 115807, MVCF 1182 Dover Road, Charleston, Maine, 04422. Thank you.
Thank you, Ms. Hunt. Any questions for Ms. Hunt? Ms. Hunt, I'm looking at the list. I don't see that we got a written testimony on that unless it just came in. Has that testimony been submitted to us so we could review it?
I will make sure that it is submitted. Thank you.
Great. And that goes for everybody else. I don't want to continue, but you are all presenting very good information we'd like to review at work session. Thank you. I now have Jan Collins.
Thank you for your patience with that process. Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jan Collins, and I am Assistant Director of the Maine Prisoner Advocacy Coalition. I am here today to speak in favor of LD 476. MPAC regularly receives letters requesting assistance from inmates or family members in prisons and jails around the state. So when I received a letter from Mountain View, the letter was not a surprise, although the contents were. An inmate who cleaned rooms in rooms in the assisted living unit had come upon a resident lying on the concrete floor in a pool of urine, immobile. He had apparently fallen and hit his head and lain there for the remainder of the night. The writer was quite distressed, but requested to remain anonymous for fear of retribution. I alerted the commissioner and then contacted the state ombudsman for long-term care. The ombudsman asked where the event occurred. When I told her that it was at Mountain View, she said that she could do nothing to assist me. There was no licensed facility at that location, and she could only work with licensed facilities. In other words, there's no outside oversight for the facility. I've since discovered that the state regulations for long-term care facilities forbids unlicensed assisted living units, which are subject to a civil penalty of not less than $500 a day and not more than $10,000 a day. I am, however, most concerned about the poor quality of care provided. Patients may suffer from terminal cancer, dementia, renal failure, or stroke. Some are bedridden, others have catheters. A man assigned to the ALU after experiencing a heart attack received no cardiac rehabilitation. The extent of his care was taking his blood pressure and checking for swollen ankles. Rehabilitative services for stroke victims are limited to full staffing, and there is no specialized dementia care. A patient who recently died of cancer died alone. He was not allowed visitors as MVCF has a policy that visits are only in the visit room, and he was bedridden and could not make it to the room. He died 6 months before release. In the experience of one person who resided there for several months, although a nurse is supposed to be present 24 hours a day, in reality, she is present closer to 6 hours and spends the remainder of the time in the infirmary. A lone corrections officer is left on duty. The 2 inmates who assist in the unit are untrained and are not allowed to touch patients except to help them in and out of bed. Their primary duties are cleaning the room and changing sheets. The question remains, why are we paying exorbitant medical costs for poor quality care when we have a community confinement policy that has been in place for decades and formerly used on a regular basis that would provide high quality humane care for much less? Please support LD 476, an act to provide licensed assisted living and nursing facilities levels of care for incarcerated persons. And I am open to questions.
Thank you, Ms. Collins. Any questions for Ms. Collins? I know that what the answer to this is already, but you'll be at the work session so we can discuss these financial issues.
I'd be glad to. Thank you.
Great, thank you. Anyone else here to testify in support of this bill? Yes. Peter, hello. Thank you for being here.
Good morning. Good morning. It's good to be here. My name is Peter Lehman. I live in Thomaston. As you all know, I served a 6-year sentence beginning at the old prison in Thomaston. I want to talk to you today about the people, both men and women, who grow old in prison and die, and their friends and their loved ones. As in our community outside, many of the leaders of the prison community are older men, some of whom die there. I want to share with you my memory of a person from the old prison who helped and guided me when I got there. Younger than I was, Dean was active in the church community and was serving a life sentence because he had a fatal disease. But he never gave up and always lent a hand. Unlike some jailhouse Christians, Dean really tried to live his faith. He helped guide and support me, this bewildered college professor in this alien land. I was not the only resident he helped. He was one of the men who supported and embodied the redemptive community that can be possible, even inside those dark walls. He died while I was at Bolduc and was buried there. I was the gardener at Bolduc and remember kneeling in my flower bed, watching the burial service from afar and crying with grief for my fallen friend. In his honor, I urge you to vote ought to pass. I'd be happy to answer any questions you may have.
Thank you, Mr. Lehman. Any questions? Seeing none, thank you. Anyone else here to testify in support of LD 476? Seeing none, I'll now take testimony from those here to testify in opposition to LD 476. If you are such, please raise your hand and Deb will move you over. And how about also if you're here to testify neither for nor against, you raise your hand and Deb will move you over now. Thank you. Commissioner Liberty, good morning, good afternoon, good morning, welcome. Sorry.
Good morning. Good morning, Senator DeChambeau, Representative Warren, and distinguished members of the Criminal Justice Public Safety Committee. I am Commissioner Liberty, and I'm the Commissioner of the Maine Department of Corrections. While the department has concerns with each paragraph of this bill, we're in opposition primarily because the services proposed in this bill are already provided. However, if the goal of the sponsor is to codify long-term care services in DOC's facilities, we're amenable to offer language for consideration that will ensure as much. I'll use this opportunity to describe to the committee the assisted living and nursing care level available to residents at the Maine Department of Corrections. Currently, the Maine Department of Corrections has 2 assisted living units, one for men and one for women, and 1 hospice unit within the infirmary of the Maine State Prison. The assisted living unit for women is located at the Women's Center, which is inside the Maine Correctional Center. This unit offers beds for up to 6 women, is located in a wing directly off the general population area of the Women's Center. The assisted living unit serves as a geriatric residence with health issues that significantly impact their ability to function, residents impacted by serious and persistent mental illness, and lastly, on occasion, women on a short-term basis who are recovering from medical procedures. It can also be used for hospice care in the event that moving a female resident to the Maine State Prison's infirmary isn't desirable. In addition to unit staff, women in the assisted living unit have on-site certified nursing assistants, regular visits by medical and behavioral health staff, including Dr. Ali, whom this committee has met virtually, and are served by volunteer residents known as Helping Hand assistants. The Helping Hand peer assistants are DOC residents trained to assist and coach their peers residing in the assisted living unit. The responsibilities of the Helping Hand peer assistant include assisting with non-medical tasks such as grooming, general cleanup, laundry, exercising, eating, general companionship. The peer assistants also offer a service that makes life a bit more comfortable for the residents dealing with long-term health issues. The assisted living unit for men is located at the Mountain View Correctional Facility in Charleston. This 27-bed facility is also equipped to support geriatric residents with health care issues that significantly impact their ability to function. And lastly, on occasion, will house men on a short-term basis recovering from a medical procedure. Like the female facility, residents in the assisted living unit at Mountain View have regular interaction with medical and behavioral health staff, and the men in this unit have their own cache of volunteer Helping Hand peer assistants. Lastly, there's a housing unit at the Maine Department of Corrections that provides nursing facility level of care. This is the infirmary at the Maine State Prison. It includes hospice beds, which primarily are used for men, but also can serve women. Residents in the infirmary, which is located in the medical staff, have regular interaction with medical and behavioral health staff. To assist residents in hospice, they are trained resident hospice volunteers. As you heard from Candace, who did a tremendous job working with the men at the Maine State Prison. The amount of service that she provided and the transformation of the men that provide that service cannot be overstated. The Maine Department of Corrections assisted living units in the infirmary are nationally accredited as part of the accreditation granted from each of our facilities by the American Correctional Association, which performs a comprehensive multi-day audit every 3 years. Maintaining this accreditation is required by state statute. If this bill is passed as written, it will require the Maine Department of Corrections to have a separate license to operate assisted living units in a nursing facility within its correctional facilities. Not only would this be unnecessary, as there are already both constitutional standards that govern the residents' care and standards required to receive our American Correctional Association accreditations, but this would also create unforeseen negative changes to our current assisted living units and infirmary. DHHS licensings for community-based assisted living and nursing facilities do not consider residents and staff safety, security, or operational needs as required in a correctional setting, as with the American Correctional Association standards do. The same is true of Medicaid eligibility criteria, which are ill-suited for a correctional context. Disregarding the correctional standards for traditional licensing standards could result in changes to security, operations, staffing, the building footprint, resulting in unnecessary costly building alterations, staffing changes, and safety risks. Furthermore, paragraphs D and E go well beyond the purview of the Maine Department of Corrections. It would be impractical and cost prohibitive for the Maine Department of Corrections to develop assisted living and nursing facilities in the community. While we are supportive of the sponsor's mission focused on community housing, the DOC is not the right agency to develop community-based assisted living or nursing facilities. The number of DOC residents needing assisted living or a nursing level of care is quite low. Although we have 27 beds at Mountain View facility, the unit is not usually full. Similarly, on the women's unit, all 6 beds are currently full, but it's not full because of definition of needing assisted living supports. It has been flexed to include individual and vision impairment, and include an individual with severe persistent mental illness. While the DOC has some success in making placements for releasing residents into existing community facilities, there are 2 challenges that are beyond our control. First, finding a facility with an opening. And second, finding a facility that will take someone with a type of criminal history that our long-term residents often have, which include homicide, arson, and habitual sex offenses. As you've heard in testimony previously, some of the staff some of the residents that we deal with in this environment throw feces and assault staff. And it's very challenging for a civilian facility to handle those sorts of circumstances. When DOC staff are working to place a releasing resident into the community-based assisted or nursing environment, we do everything in our power to encourage the provider to take the individual. But our encouraging cannot override a community's facility's insurance, space, staffing, or safety concerns. Furthermore, the objection of the victim to need to be considered whether the placement in the community is still being contemplated. Paragraph E also asks the DOC to provide training to existing community-based facilities in supporting the needs of any resident placed in our facility. While the DOC would love to have staffing numbers and time to provide training to any community-based facility in which a resident would be placed, it's just not possible and not appropriate for a medical team to tell other medical teams how to do their job, though we currently do our best to address any concerns a community-based facility may have when they accept a DOC resident. Lastly, there is a request for the bill for rulemaking, which we cannot support as it would not allow for flexibility to change course should an unforeseen circumstance arise, given in this correctional world that we live in. For example, if the women's unit kept to a rigid definition of need for assisted living, as rulemaking would suggest, at least 2 of the 6 women in the unit currently would not be able to stay in the assisted living unit. This would require their placement in other housing, but not within general population. It would also mean that they would not have the benefits of a helping hand peer assistant or the more frequent interaction with medical and behavioral health staff as they currently do. There is no doubt in the mind of the warden of the Women's Center that removing these women from this unit would be a detriment to their health and well-being. For many reasons, we oppose this bill, but the good news is that opposing this bill doesn't change the many services currently provided to residents of the DOC needing assisted living and nursing levels of care. As a sign of support and understanding of the sponsor's hope of codifying into law these services, we'd offer to the sponsor, and we have offered to the sponsor and the committee, suggested language change that establishes into DOC statute for long-term care services requirement. And I've included that in my written testimony. And that suggestion would be the commissioner shall establish and maintain or contract for long-term care services, including assisted living and nursing facility levels of care for prisoners whom such services are necessary as determined by the facility's treating physician. This concludes my testimony, and I'm happy to take questions. Thank you.
Thank you, Commissioner Liberty. Questions for Commissioner Liberty? Yes, Senator Searway.
Thank you, Madam Chair. Thank you for the great presentation on what you currently do, Commissioner. What would this amendment that you're proposing, would that be an added cost to what you currently do?
I see no fiscal impact with the amendment that we've friendly offered.
Okay, well, thank you.
Other questions for Commissioner Liberty? Yes, Representative Lookner.
Thank you, Madam Chair. Thank you, Commissioner Liberty. So is it WellPath that provides these services within Maine's correction system, that does this hospice care, in WellPath is equipped, in your opinion, to provide that level of service?
Yes, Representative, they are equipped to do the behavioral health and mental services of the Maine Department of Corrections. The hospice work that happens was created by Candace Powell, who you've heard from, and she created the training and the mentorship and the direction for those hospice workers at the Maine State Prison. And I had the opportunity to witness some of the people that presented in action, providing comfort care, hospice care, as a result of the work that Candace did over many, many years. And it was phenomenal care. And again, my hat goes off to those workers that are residents of the facility and to Candace for the really transformational work that she did.
Thank you.
Representative Pickett.
Thank you, Madam Chair. Good, I guess, afternoon, Commissioner. Good afternoon. What I wanted to ask you is the American Correctional Association, the accreditation you have from them, because they're, in some of the testimony I've heard, and some of it seems as though there's a thought process that the care and maybe is not up to the standard it should be. I'm not saying it isn't. I'm just saying, but to get that accreditation could you explain a little more on how difficult it is to get that accreditation, so that it's not just a matter of applying for it and getting it, and that your standards and what you're doing is the kind of care that these residents need, and it's very consistent with what's being given on the outside as well, when you're having it performed on the inside. Could you speak to that for a few moments, please?
Yes, thank you, Representative, for the question. The ACA accreditation process is required by statute. Each of the state facilities must be accredited every 3 years, as is Somerset County and Cumberland County by volunteer. It's an extensive 3-day process where specific to medical, and I can give you more detail, more testimony related to that in the work session, specifically about the criteria and the different standards, both mandatory and non-mandatory standards. And normally a 3-day process where our medical providers work with the inspectors that are also prior wardens, prior medical providers in a correctional setting. They go through all the folders to verify that the standards are met. They inspect each of the facilities. They do inventories. They do an exhaustive 3-day workup of each of the medical facilities within the Department of Corrections. And so it's exhaustive. It's anyone that's been through the process will tell you there's quite a ramp up to make sure you document and things are addressed throughout that time frame. And then the 3-day process that is required for the actual on-site inspection from these correctional professionals is exhausting and ensures that medical treatment is appropriately delivered.
Follow up?
Yes, please.
And Commissioner, these people, as you just described, these people, when they come in to do this audit and this inspection, they have prior experience with dealing with a correctional facility and how these things need to be run and should be run in a correctional facility. And in your opinion, does that make that accreditation all the more pertinent to what you're trying to accomplish within your facilities?
Thank you, Representative. In my experience, the numerous inspections that I've been engaged in, all of the inspectors have more than 30 years of correctional experience. Many of them are wardens, former wardens, some are active. Many of them were full-time medical providers in a correctional setting. They are truly national subject matter experts to be selected as inspectors for the American Correctional Association. Not only do they inspect, but they also give some guidance and mentorship. And one of the big values that they bring is, since they do so many audits and they've seen so many correctional facilities and medical services nationally, many of them have been more than 50 audits, they can bring sort of tricks to the trade, helpful hints, things that they've learned from Alabama, Georgia, California that they can give to us to make our operation more efficient. So I found it to be very thorough, very exhaustive, and very helpful.
Thank you, Commissioner.
Other questions for Commissioner Liberty? Commissioner, so are you saying that because the facility has accreditation, it doesn't need to be licensed as a long-term care facility?
Yes, that's what I'm saying. Thank you.
Okay. And my second question is, as I've asked other people, I'm going to be really interested in talking about the cost to Maine taxpayers of us shouldering this cost as opposed to having the care done outside the facility where it can be covered by Maine Care. I don't remember what the statistic is, but I remember that it's a very large percentage of money spent at the very end of people's lives. We can go through all of these decades of our life, and in the last year, we end up spending for care, some astronomical number of money compared to the rest of our life. And if we're talking about, we can either have that care provided in a way where Maine taxpayers are paying 10% as opposed to 100%, or whatever that percentage is, I'm going to be very interested in talking about that. So I know you'll be at the work session, so I won't ask you that, but just to give you a heads up. Did you want to add anything about that? Or
I would just say that the largest challenge that I've seen as we try to find placement in the community, as anyone knows they're involved with an elder, trying to find a bed in some of these facilities is very challenging. And especially when we present the nature of some of these crimes, the facilities are very reluctant to place them. That has been our major challenge. When someone has, extensive sexual charges or homicide charge, and when the administrators do a risk assessment, it becomes very difficult to find placement in these facilities. That's been my challenge.
Thank you for that. Senator DeChambeau.
Yes. Thank you. Commissioner, you jogged my memory. You were talking about ACA standards. Are all the facilities accredited now?
Yes, Senator, all of our facilities are accredited by ACA.
Okay. Is there a score that is relative to each facility when they do accreditation? Like how
Yes.
many standards they met or what?
Yes, Senator, each of them receives a numeric score. And for the work session, I'll give you a history of the scores that our facilities have received, many of them receiving 100s on all of the standards that are inspected. The one standard that is occasionally missed is one that relates to the ability to recruit and retain. That's often a national challenge for our industry. But I'll be glad to give you historic numeric scores for each of those. And I think you'll be very pleased with the numbers that we've been able to achieve.
Thank you.
Other questions for Commissioner Liberty? Seeing none, thank you. Anyone else
Thank
here
you.
to testify in opposition to LD 476? Seeing none, anyone here to testify neither for nor against LD 476? I think seeing none. Deb, am I all set?
Yes.
Great, thank you. Seeing none, we'll close the public hearing on LD 476. Thank you all for being here. Next up, we'll have please. Yes, sorry about that. Hi.
Yeah, Representative Pickett here. I just wondered if, where it's 20 after 12, if we took a short break for lunch and then we'd have the whole afternoon to finish the rest of these off, because we still got 3 more bills to do, several more bills to do. Didn't know where this was the first one, if that might be a good time to just grab lunch.
I'm fine to do that if we did it very quickly. Senator, what do you think about that?
Well, even if we said quickly at 1:45, we'd start at 1. I just, Representative Pickett, we are at our homes. How much time do you recommend for those of you who are there?
What is it, 20 after? We should be able to be back in 30 minutes.
All right. So at 12:50.
Okay, thank you.
All right. Yeah, thank you. And Deb, you heard that, so we can alert the other members, the other people.
Yes, I'll put up the break sign.
Thank you. See you in 30 minutes.
I just got the call from the hospital. I have my shot scheduled Friday morning at 8. Oops, you're on
That's
mute.
awesome.
Yeah, I know.
The relief.
Freedom is coming.
The Augusta Maine General?
It was Maine General that called me, and I'll have my shot done at the Civic Center at 8 a.m. on Friday.
Okay. Do you know which one you're getting? Johnson?
I don't know. It's going to be a 2-part. Yeah. I just want to see, I just like, my oldest niece is a direct care worker, so she has to be really careful. And I just want to see her again, you know.
Charlotte, I didn't think you were old enough to get a shot.
Thank you. I'm 50.
I cannot believe I am 23 years older. I could be her mother.
Yeah, my mom is 75.
Oh, God. Come
Wow.
take care of me.
Oh, I got enough taking care of her, let me tell you. Yeah, she's all vaccinated though, so that's wonderful for my family. That's been our biggest worry. I took her out this weekend. So.
Yeah, my father-in-law is 88 and he's like the Energizer Bunny. He just had his second shot yesterday and it was out cutting brush on the side of the road in front of my house all day long. And I couldn't believe it.
You said 88, Richard?
88.
I love it. I love it.
Well, we have a quorum, so we can get going. The others will fall in. All right, let's begin again. I'm going to ask Deb if we're still on YouTube. Are we
Yes,
live?
we are.
Okay, thank you. Well, good afternoon. We will continue with our schedule. We have 5 bills this afternoon. I am Senator Susan DeChambeau, Senate Chair, and Representative Charlotte Warren is the co-chair in the House. And since this is a new one, why don't we just walk by who is here. Let me, Representative Pickett.
Yes, thank you, Madam Chair. My name is Dick Pickett. I represent House District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru.
Thank you. Senator Searway.
Good afternoon. I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Fairfield, Benton, Clinton, Unity Township, and Albion.
Thanks. Representative Dan Costain.
Thank you, Madam Chair. District 100, which is part of Etna, Dixmont, Newport, Plymouth, and Corona. Thank you.
Thanks. Representative Morales.
Good afternoon. My name is Victoria Morales, and I represent House District 33 in South Portland.
Representative Pluker.
Hi, I'm Bill Pluker. I come from House District 95, which represents Warren, Hope, Appleton, and part of Union.
Thanks. And Representative Renicki.
Good afternoon, and mine from the Capitol. I am State Representative Shelley Rodnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield. And again, we need to get back so that we're all actually talking face to face. Thank you.
And Representative Warren will be presenting her bill. We also have our policy analyst, Jane Orbiton, with us, and our clerk, Deb Fahey. So moving right along, we do have LD 477.
Madam Chair.
Yes, excuse
I'm
me.
going to be here. I'm going to be here with you all afternoon. So please let me go after. We have other representatives that are here for their bills.
Yep.
And let's get them going and I'll be last. I'm happy to do that.
Okay. I should have realized that. And For those of you who read my posts, I was wrong. We're gonna do LD 491. Let me go over the other bills so in order. So we're gonna do 491 followed by 514, 514, LD 421, LD 661, and we'll end with Representative Warren's LD 477. Again, I think a couple of those are legislators, and they're juggling testifying at different committees also, so it may change a little. So let's go with 491, an act to create the crime of hate crime, false public alarm or report. And that is from Senator Marmont. Is Senator Marmont with us? And if anybody wishes to testify, please raise your hand and we'll bring you in as okay. Do you see him on the participant list?
Yes, he's here.
Okay.
Hello.
Hi. Welcome, Senator Marmont.
Thanks. Fun watching your committee this morning.
Okay. This afternoon?
Yeah.
Okay.
It's like my committees, except for Marine, which you know that. I won't rub it in.
So go right ahead on your bill.
Thank you. Good morning. Yeah, we go. Good afternoon, Senator, Representative Warren, and distinguished members of the Criminal Justice and Public Safety Committee. My name is Dave Marmont. I proudly represent all of the people of Appleton, Camden, Cree Haven, Cushing, Friendship, Hope, Idaho, Matinicus, Muscle Ridge Islands, North Haven, Owl's Head, Rockland, Rockport, South Thomaston, St. George, Thomaston, Union, Vinyl Haven, and Warren in the Maine Senate. Good thing that
God's country. Go ahead.
I come before you to present LD 491, an act to create the crime of hate crime, false public alarm or report. We've been witnessing the effects of the underlying endemic racism in our country. This past year, the news was dominated by stories of people responding to racial injustice at the hands of the police and racism expressed in other ways that are more subtle but no less disturbing for their frequency. I cannot know the experience of feeling like a stranger in your own country just because you look different, or the ways that a person of color must adjust how they react to the overt and covert differences in the way they are treated. I have a sense of the pain and betrayal they must feel when they are accused of doing something that they have not done, when they also know that the system can be used against them even in their innocence. We saw such a case that was recorded in New York Central Park last year when a woman tried to control a Black man who was enjoying the park, but since she was in fear based on her prejudice, she tried to use the police against him with a reasonable expectation that a white woman would be believed over a Black man. While this is in New York, I've heard racist sentiments and witnessed actions here in Maine that make me want to ensure that there is a strong disincentive to such behavior and beliefs. This bill makes it a crime to file a false report based on prejudice and profiling. It should be passed, and the results should be broadcast around the state loudly and frequently until not even one person would dare to disrupt the life of an innocent person with such a cruel act. The bill speaks for itself, and there's other people here to talk about it. So I thank you for your consideration, and we'll try to answer any questions.
Thank you. Are there any questions of the sponsor, Senator Marmont? Seeing none, we shall continue and ask for testimony. I have a couple of pages. For those of you who are not familiar, please, when you are asked to testify, please state your name, your residence, and any organization you represent, and you have a 3-minute limit on your testimony, please. And who would like to speak in favor of this bill? I have, let me see. I have if he's here, I can follow this list or raise your hand and I'll recognize you that way. Okay. And Miss Former, right? Go right ahead, Miss Former. You are muted. Thank you.
Okay, unmuted. Yes, thank you. I'm glad to be here to say that I am in favor of Senator Merriman's bill. I'm not terribly familiar with how we do this. I'm used to local politics and such. So anyway, I say that Maine should not tolerate hate crimes because
Ms. Former, could you tell us where you're from and if you represent any organization?
Oh, so sorry. I'm from Rockland, Maine, and I represent humanity.
Well, that's good. Go right ahead.
I care about human beings. All human beings matter to me, and this bill makes sense. It's sensible. I like things that are sensible. And that's pretty much all I have to say.
All right. Thank you very much, Ms. Former. Suzanne Rutledge, do you wish to testify today? Okay. Go right ahead. Thank you.
Good afternoon, chairpersons, Senator DeChambeau and Representative, or maybe she's not still here, Warren, and members of the committee. My name is Suzanne Rudalevich, living in Cape Elizabeth. I'm testifying on behalf of the Anti-Racist Policy Committee of the Hope Gateway United Methodist Church in Portland. I am not usually in favor of creating new crimes and new punishments. However, as a group, the practice of white people of calling authorities on African Americans and other persons of color has not abated. Whether through unfounded fear or entitlement born of white privilege, this behavior overrides another person's civil rights. I therefore believe that action is called for. And Senator Merriman has already mentioned the New York Park incident, which I was going to refer to. We must deter by law what we do not seem to be able to control by civic decency. I don't know if Class C is the appropriate penalty for this crime. I do not think that prison time changes people's minds about racist beliefs. I am an advocate of restorative justice, and I would rather a consequence that might include appropriate education and thoughtfully placed community service. Thank you for listening. I'm happy to answer any questions.
Thank you, Suzanne. Anybody have any questions for Ms. Rudalevich? Seeing none, I will continue. Again, I have a couple of places. Is there anybody else that needs to come in? I will.
Mr. Christian has his hand up, Senator.
I have Christian Reynolds. Is that who I'm looking for?
That is correct.
Okay, Mr. Reynolds, please, are you joining us?
Yeah, I should be. I don't see my video. I just see a picture of myself. Start video. Okay, there we go. Good afternoon, committee, Criminal Justice and Safety Committee. Thanks for having me and allowing me to give my testimony. I am in support of the legislative document number 491. My testimony reads, my name is Reynolds Christian. I am a constituent and resident of the city of Boston. Prior to supporting such bill, my position was a dispatcher of the Boston Transportation Department. I'm writing this letter because I support this bill. Having been affected in such acts of false public alarm while being swatted by the Boston police back on November 20th, 2020, triggers how Black men are perceived and treated in their own communities. Being very afraid to travel in the Maine area after having this experience is alarming. I am aware that this can happen in other states such as Maine and Massachusetts, where such laws has not been yet passed by the House. Urban communities experience these issues by individuals and underlined in essential facts that hate crimes are a national problem deserving a priority attention. The federal government has an essential leadership and role to play in confronting acts of violence motivated by prejudices and in promoting anti-bias initiatives by public accommodations, schools, communities, and lawful enforcement officials. One of the greatest challenges to understand is the severity of magnitude of false alarm hate crimes is a lack of sufficient data. Developing effective policies, procedures, and responses to hate crime can reduce overall crime while simultaneously building relationships and trust between law enforcement and communities who feel targeted by acts of hate. Out of all crimes, hate crimes are the most likely to create an exacerbation tension, which can trigger larger community-wide racial conflict, civil disturbances, even riots. Furthermore, these crimes can then impede the work of law enforcement in prosecution, investigating, prosecuting, and preventing all crime. Recognition and reporting the hate crime and incidents is critical to raising awareness of the problem, acknowledging to victims the pain bias actions cause, and helping police and prosecutors better understand where and how such incidents occur. For so long, we have only been seeking conflict resolution and a better understanding of how these acts have affected the population of minority and what can be done to resolve this matter. Please support docket number 491 as it will bring some sense of awareness and safety in our communities when derived from such hate crimes false public alarm.
Thank you, Mr. Christian. I misread your name. I apologize about that. Dorchester, is that Dorchester from Massachusetts? From Massachusetts.
That is Dorchester. That is correct.
Okay, thank you. Any questions for Mr. Christian? Seeing none, I shall continue.
We also have one more person on the phone as well. If you guys would allow them to speak, they're actually on my line. They wasn't able to chime in from the Zoom link.
Have they registered to speak? I have a list, that's why.
Yes, what's your name?
Yes, Beth Berry from Rockland.
Okay, Beth, you are on the list. Go right ahead.
Thank you, Madam Chairman and the committee. I wish to speak in favor of LD 491 and act to create the crime of hate crime, false public alarm or report, which I waited all morning, but for some reason my phone went dead, and then you're trying to get quorum and all of these things. Anyway, I couldn't get into the hearing by phone, so this young man was kind enough to get me through, so thank God. In social psychology, it is taught that when a white man goes into a room with a black man, the white man's blood pressure goes up. This is taught in college, but not at the police academy. By the way, I learned that from Professor Yelland up at Orono. Would George Floyd be alive if the white officer whose biological adrenaline he can't control was aware of his unconscious bias? Penn Bay Medical Center security unprofessionally caused false public alarm repeatedly by calling police on my family of color falsely for peacefully trying to follow the law and make legal service while of color, etc. Sergeant Brown heroically told the security supervisor to stop harassing us, and yet they don't. A federal level complaint was made, who sent it to Maine DHHS, who refused to investigate. And I have that letter in case anybody would like a copy of that. Racist neighbors call the police after they make death threats against my disabled son and tell us to move, and use police as a weapon for their hatred with immunity. Rather than arrest the white supremacist, police called DHHS on us, adding insult to injury. A racist neighbor called the police on my daughter for, quote, being suspicious, end quote. She was parked outside our family's driveway of 4 generations after exhaustion from working 3 jobs. This bill must pass for Martin Luther King Jr.'s dream to come true. I hope you will support it as the Honorable Senator Merriman does. It is the ethical and morally correct bill to support today. Medical apartheid is too often practiced by doctors who believe they are above the law and get away with crimes like what was committed against my son of color. Unconscious bias unauthorized and conscious bias need to stop being acted upon without consequence in Maine. Deliver us from evil. Blessings to you all on the committee. Thank you, Beth Berry. Lachlan.
Thank you. Any questions of Ms. Berry? Seeing none, I will continue.
Thank you.
Thank you.
One more person.
Hi, my name is Theodore Berry. I'm on the list, and I don't have the electronic equipment to speak other than through this means, please.
Is this Theodore Berry?
Yes, this is Theodore Berry. Good afternoon.
Good afternoon. You may proceed, sir.
Thank you very much. My name is Theodore Berry. I'm from Rockland. I was horrified by the Amy Cooper, Christian Cooper, Central Park occurrence. It frightened me so much, and it personally hit me. It happened to me so many times at this point that I contacted Senator David Merriman, and I drafted an original draft for him to present to this committee. Last year, I was standing on Main Street in Brunswick, Maine, minding my own business, talking on a cell phone. No one was around me, other than my mother, who was in a car. No one was around me. I wasn't bothering anybody, but for some reason, out of the blue, not one, not two, not three, but 4 Brunswick police cruisers surrounded me. And me. And my mother. Not 1, not 2, not 3, not 4, not 5, not 6, but 7 Brunswick police officers surrounded me. Standing in a public place, on a sidewalk, not doing anything to anybody of any kind. I am surrounded by police. I have no idea why. I'm approached and I'm informed that they don't know why they're there. It was my car. And then, because they don't know why they're there, and I don't know why they're there, then it turns into an issue of cognitive confirmation bias. If I weren't African American, the police would just leave. But because I'm African American, even if when the police come and they don't see any problem, then the increased scrutiny begins. Then the improper inquiries begin. Trying to ask questions about any type of crime that they could possibly think in their head that I could have committed. Standing on a sidewalk in a public place, doing absolutely nothing wrong. And after being subjected to 10 minutes of, have you been drinking, sir? Is my car? Is this your car, sir? Do you love your mother, sir? And then after getting through the racial abuse and the torment and the increased scrutiny, it ends with being threatened with arrest. And if my white mother hadn't been present, I would have been arrested.
Mr. Berry, could you wrap up? Your 3 minutes is up.
Yeah, I wanted to wrap up.
Okay. Long story short, this is definitely needed because the severity of being given the ultimatum of prison or hospital to people of color is outrageous. It's abhorrent, and this is a real thing. Even if people that are white have never experienced this and will never experience this in their life.
I was actually hospitalized behind the scenes.
Thank you. We've had enough testimony on that, and please don't interrupt.
Sorry about that.
So Mr. Berry and Ms. Berry, thank you very much for your testimony. Anybody have any questions for Mr. Berry? Hearing none, I will continue. Anyone else wishing to speak in favor? I will then ask anyone wishing to speak in opposition, against. I have Michael Cabetta.
Thank you, Senator DeChambeau, Representative Warren, and distinguished members of the committee. Good afternoon. My name is Michael Cabetta, and I am Policy Counsel for the American Civil Liberties Union of Maine. On behalf of our members, we urge the committee to reject this bill. Our country has had a long and disturbing history of people using police to enforce social and economic hierarchies. It's undeniable that some Americans incite police against members of marginalized communities for no reason other than to put that person in their place. As previous testifiers described, Amy Cooper's notorious 911 call in New York's Central Park last summer to report Christian Cooper, an African-American birdwatcher, vividly illustrated this notorious practice. We are extremely sympathetic to the desire to punish people like Ms. Cooper for misusing law enforcement. However, the committee must reject this bill. Police, prisons, and the criminal legal system are not the way to solve this extremely serious problem. We often stand before this committee and object to the creation of new crimes because creating felonies does not stop abhorrent behavior or address its underlying root causes. This bill is no different. Creating a Class C felony will not keep marginalized people safe. Indeed, people who harm because of hate do not learn their lesson in prison. Instead, they often double down on these views. There are forms of dispute resolution better suited to this problem. We urge you to learn about and to fund and support transformative justice practices in Maine. Let us remember that Christian Cooper himself declined to cooperate with prosecutors and press charges against Amy Cooper. Let us follow his lead and think outside the criminal legal system. I applaud Senator Merrimant's desire and the desire of previous testifiers to solve this problem, but this bill is not the way. We urge you to vote ought not to pass. Thank you, and I am happy to try to answer questions.
Great, thank you, Mr. Cabetta. Any questions from Mr. Cabetta? Seeing none, thank you. Is Walter McKee here? Mr. McKee?
He left to get his COVID shot.
He's here. He has his hand up.
Oh, he does? Okay. And then I have William Ross and John Pelletier can come in. Good afternoon, Mr. McKee.
Good afternoon. My name is Walt McKee. I'm here on behalf of the Maine Association of Criminal Defense Lawyers. My left arm is sore. I did get my shot and I made it back in time. So thank you for actually accidentally scheduling it this way. MACDL opposes LD 491. Like others, we see the reason why a bill like this might be offered. But our position is a little different in that we see that the current penalties for conduct just like this are significant and severe, and that new felony crimes really aren't appropriate. I'll remind the committee, as the committee is well aware, that a Class D offense carries with it up to 364 days in jail, a significant penalty that can be imposed on someone that engages in this very conduct. I'd also indicate to the court, this committee, that the court is in a unique position to obtain additional information and facts and circumstances to levy a more significant penalty within the range of 0 to 364 days in jail, to take into account the very considerations that this bill has been brought forward for. A simple Class D crime without these other factors might merit some level of punishment, but one that has additional factors, especially when it comes to race, can, in the court's opinion, based on those facts and circumstances, merit a more significant penalty. That's kind of part of the process of sentencing. And I think that what we have talked about time and again is that we need to let the judges do the judging. This is a perfect example of that. A judge should or could take into account these very circumstances and say, this is a more serious type of Class D offense. I believe a sentence should be more significant. It should be twice, 3 times, 4 times. Because of that particular factor that makes it a true aggravating factor. Our position is the judges can do this. There's a significant range that the court will be allowed to sentence a defendant in as it stands right now. and creating a new felony crime would be inappropriate. Thank you for the opportunity to speak today.
Thank you. Any questions for Attorney McKee? Great. Seeing none, thank you. I have William Ross.
Good afternoon, everyone. My name is Major William Ross, and I'm here to represent the Department of Public Safety and the Maine State Police to testify against LD 491, an act to create the crime of hate crime, false public alarm, or report. The state of Maine has no specific hate crime statute, but an established process to address hate crime is in place. Adding the hate crime or bias language to this statute or any other would present significant challenges for law enforcement and negatively impact successful prosecution. All crimes are investigated by law enforcement, and when enough evidence, probable cause of the crime has been determined, enforcement of that statute takes place. Law enforcement, during their investigation, will have gathered evidence, conducted interviews, and documented these findings in a report before the case is submitted to the prosecuting authority. The hate crime or bias aspect of the proposed bill will put the burden on law enforcement to not only provide evidence of the elements of the existing crime, i.e. false public alarm or report, but to determine the motivation behind the offender's actions. This nuance makes enforcement considerably more difficult, as uncovering an individual's motivation for committing a crime isn't captured as easily or clearly. Law enforcement investigations with subsequent enforcement must provide how the crime was committed, but doesn't necessarily need to establish why the crime was committed. This bill, if enacted, would make the offender's motivation part of these elements of the crime and considered for a law enforcement officer's determination of probable cause. It will also need to be proven beyond a reasonable doubt for successful prosecution. The hate crime or bias aspect of any criminal act is presently and most effectively handled by the prosecuting authority through the Maine Criminal Code by either the Attorney General's office or the respective district attorney's office under the general sentencing provisions, title, which would be 17A. I initially put 1151, but it's 1501. And I quote, the selection by the person of the victim or of the property that was damaged or otherwise affected by the crime because of the race, color, religion, sex, ancestry, national origin, physical or mental disability, sexual orientation, or homelessness of the victim or of the owner or occupant of that property, end quote. In addition, law enforcement agencies can make referrals to the Attorney General's office where these crimes or incidents can be addressed through the Maine Civil Rights Act. The hate crime aspect of any crime is already addressed universally through the existing law, which would avoid adding this kind of language to this specific statute. For these reasons, I strongly urge the committee to vote ought not to pass on this bill. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time. We'll be happy to try and answer questions that you might have.
Thank you, Major Ross. Any questions? For some reason, okay, we do have questions. I have Representative Reckett followed by Representative Lookner. You're muted. Lois, thank you.
Major Ross, thanks for appearing today. I have a question based on something you said, and I don't know if I heard you correctly. So you should clarify that if I haven't heard you correctly. It seemed to me you said that for a incident to be elevated to a hate crime or to add an element of hate crime to a incident, it's the responsibility of the prosecutors to make that decision. Is that what you said?
No, it wouldn't be the responsibility of the prosecutor. They potentially could. And essentially, once we show that there's probable cause, we present our case to the district attorney's office, several avenues to approach either through a referral to the Attorney General's office, which could also be done by law enforcement. I think the district attorneys would be able to pursue the criminal case, and if a conviction had come down, then through different sentencing provisions, they would have more control of what the outcome would be at that point.
Thank you for that clarification. Do you know that whether or not this route is routinely taken by district attorneys? Have you heard of instances where they presented the details of the incident as an aggravating factor in sentencing, or however it's articulated?
I know of specific cases that this process has been used. One in particular was a assault case in southern Maine recently that made its way up through to the federal courts and the U.S. Attorney's Office, where they've had a successful prosecution, which led to the two offenders, one being sentenced for 10 years, the other one being taken a plea for 5 years. And a pretty high profile case just within the last year. And then there's other smaller cases that I can't speak to directly, but I know it's not used commonly, or probably not enough as it should be, as I think these types of incidents are underreported, and certainly literature out there indicates that they are. And but I think through this process is really the best way, particularly for law enforcement and law enforcement investigators, to go about these types of cases, is handling the specific crime as it's written now, as opposed to putting hate crime or bias crime language into it, because of that element of showing why, getting into a person's head and trying to explain why makes it extremely difficult to get over that hurdle beyond a reasonable doubt to have a successful prosecution.
Thank you, sir.
Representative Lookner.
Thank you, Madam Chair, and thank you, Major Ross. So it's already illegal to call and activate EMS, the police, on somebody for false premises. Is that correct?
Yes, that is correct. Correct.
And what level of crime is that? I call the police on my neighbors because I don't like them for some reason. And it's determined that I did that based on a false premise. Like, what level of crime is that?
So I believe correctly, it's a Class D crime.
Okay, so is that a felony?
No, that would be a Class C crime. Class B and Class A would be considered felonies.
Okay, so it's a misdemeanor. Okay, and you said it's hard to prove already, or it's underreported that these things happen, but it's just underreported.
Well, two things. The underreported part of it, I'll put off to the side for a moment, but difficult to prove, because by adding the hate crime or biased language to the existing crime, you now have to prove why the individual committed this crime. So you have to kind of get into their head and show what their motivation is. And most of our criminal statutes, you don't have to prove what the motive was. You just have to prove that the actual incident occurred, how it happened, who the offender was, identifying who the victim was. So in the process that we have now with that model, there's sentencing provisions, there's civil injunctions the Attorney General's office can move forward with, and certainly for referrals to the federal courts, U.S. Attorney's office, to handle these types of cases. That hurdle to get over the burden of proof of beyond a reasonable doubt on motive is extremely difficult to do. Some of the bigger cases I've worked on, homicide cases, murder trials, you just have to show how the crime occurred. You don't necessarily say why it occurred. You can certainly present evidence of why it occurred, but you don't have to show that element beyond a reasonable doubt. And when you add that to it, it becomes really difficult to for law enforcement to get to their burden of proof, and certainly for prosecutors when those types of cases end up in trial.
Okay, thank you. And I guess, do we have an idea of how many instances of, misreporting there have been, over the past couple of years of, somebody calling the police on anybody based on false, activating EMS on somebody for a false premise? Is that something that's commonly prosecuted?
I would say it's not commonly, it's not unheard of. Typically you hear people using Miss 911. I have not seen any statistics on that particular statute. But which is interesting about this, I think you could also apply this language, hate crime, bias, to certainly assault, criminal mischief, criminal threatening, terrorizing, all of these types of crimes. And that hasn't been done. And I think the reason why the optics of it look good, but in reality, when you're trying to conduct an investigation and present it to a prosecutor, that motivation hurdle, that element of the crime, really makes it extremely difficult.
Thank you. And I guess just last thing, I'm not talking about hate crimes here specifically. I'm just talking about activating EMS on anybody on false premises. That crime, that Class D crime that you were describing, is that common? Does that happen a lot in Maine? Do you think that's underreported?
I think so. It happens in Maine. I don't think it happens a lot in Maine. And in terms of it being unreported, I think what would be unreported would be the hate and bias associated with that crime. I think that's where the issue is. Those types of crimes are underreported.
Okay, thank you.
Representative Lookner, I can tell you that municipalities have data on misuse of 911. And what's been reported to me by chief law enforcement officers, they could use, and I'll direct you to page 94 of Vertigo, the crime of false report. They could use that, but a lot of them are people that they know who have issues and problems, and it's more misuse of 911, and they're not arrested or anything. So,
thanks for that, Senator.
Okay, Representative Morales.
Thank you, Major Ross. A question, are you aware of Criminal Justice Academy or dispatch trainings around the misuse of law enforcement?
Thank you for the question. Could you just be a little more specific of what you're asking? So the training academy and dispatch training, being aware of the misuse of reporting incidents?
Right. Sorry if that was confusing. Are you aware of any trainings at dispatch or through the Criminal Justice Academy that touch on, that train on, that educate around the misuse of law enforcement, like we're talking about with this bill today?
Not specifically on the misuse of law enforcement, which certainly this is what this bill is attempting to address. There is other types of training on implicit bias and so on and so forth, but I don't think that's what you're asking me. But I am not aware of any particular training based on misuse of law enforcement services.
Such as making a call,
such as making a false report or using the police in some of the examples that were provided earlier. I'm not aware of any particular training pertaining to that.
Thank you.
Major, let me ask you, is that something that Sam Hurley of your department would know about the training, or what? I'm just asking, I'm not sure. Is he not the director of EMS or dispatching?
Thank you for the question. He is the director of EMS. I think that question could go to a couple of different places.
Okay.
The communications director, Brody Hinckley, would potentially be somebody who oversees the regional communication centers for the state, but not all of the regional communication centers.
So maybe what I'm also asking for our work session, could you get that information for us for the work session on the kind of training the dispatchers receive at the academy pursuant to this issue?
Absolutely, I'll make an inquiry.
Great, thank you. Representative Morales, do you have another question? Okay. Seeing no more questions. Okay, well, thank you, Mr. Ross. So that brings me to, is anyone else wish to speak against the bill? I then go neither for nor against, and I have Mr. Pelletier's name. Is he with us? Mr. Pelletier?
I don't see him.
Okay. We probably have his testimony from Clack. Good. So members take note of that. Clack has a statement on that, I'm sure, for testimony. Thank you. Anyone else wish to speak neither for nor against? Seeing none, I'll close this hearing on LD 491. And Ms. Overton, have we decided when a work session will be held on these? No? Do we have a date?
We don't have a date. We had one, but then it had to be canceled.
Okay.
So we'll let people know.
Okay. And I will also let the public know, we do have schedules for 2 or 3 weeks out. And next week, 2 days are dedicated to sessions. So that really had to make adjustments to the schedule. Thank you. Let's see. I now have LD.
Thank you, Senator Miramont.
Oops.
Thank you.
God. Bye-bye, Dave. LD 514, an act to establish and promote a system of safe disposal. Oh, before I continue, is she here? Representative McCray? Good. So an act to establish, promote a system of safe disposal of expired marine flares. And the sponsor is Representative Jay McCray. And we're gonna hear this again. We really are working this bill and other bills we've had. Thank you. Go right ahead, Representative McCray.
Thank you.
Welcome, Representative.
Hi, everybody. Well, I'm here today to present LD 514. As just mentioned, an act to establish and promote a system of safe disposal of expired marine flares. And some of you have heard this before. This was one of the bills that unfortunately died last session and has been an effort of 5 years in the making. I bring it forward again because of its importance for commercial fishermen and women, recreational boaters, for fire safety, and for prevention of pollution of land and water. This is something that no state has solved, but Maine can through passage of this bill. The origin of this bill was a seemingly simple question from a constituent, a local lobsterman, who asked, "What am I supposed to do with all these expired marine flares? My basement's full of them, and so are those of everybody else I know." My first thought was the risk to first responders who could enter a building unaware that these highly flammable devices are there. Flares are specifically designed to burn hot and long, and even after expiration can still be active. My second thought was that I would find a quick answer and get right back to him. Instead, I learned that the advice out there was incorrect, contradictory, and dangerous. Even though there's been some updating of advice recently, harmful practices persist. These pyrotechnic visual distress signals are required by state and federal law on commercial boats over 16 feet and recreational boats in tidal waters. Active flares are required as essential safety equipment, but they expire in 42 months and must be replaced. Therefore, the question, what do I do with the expired ones? Common but bad advice includes shoot them off for practice, possibly causing a false distress call from the Coast Guard. Or soak them in a bucket of water and throw them in the trash and dump out the water, resulting in polluted water and soil. Marine flares contain percolate, a toxic hazardous chemical. Another misconception is that hazardous waste companies will take them. They don't. Some marinas still assume it's okay to just shoot them off on the 4th of July. But the Coast Guard stopped giving permission because too many have caused fires on boats and docks when they land incorrectly, and because when they land in the ocean, they pollute. Another common suggestion, just toss them overboard. Again, pollution. Keep some on board. They just might work in an emergency. This is actually sound advice. But for safety, for space, and by regulation, you can't keep them all on board. The expired flares that are kept must be limited in number and specifically labeled. The most common suggestion for getting rid of expired marine flares is to take them to the Coast Guard, to the fire department, to the transfer station. The Coast Guard no longer accepts flares. Transfer stations are not permitted to accept them, though they've been found at the gates after dark because people don't know what else to do with them. Most fire departments are not willing to accept them, and even those few that do have no way to dispose of these flares themselves. Bottom line, we need a solution available to the fire marshal's office. The number of expired flares sitting in basements, shed, garages is unknown, but I can tell you that after this bill first was introduced, the fire marshal has received over 2 tons of them, and they keep coming. Since that seemingly simple question, I've worked to find a low barrier, low cost, responsible, and efficient solution. Along with fire safety and environmental experts, recreational boaters, commercial fishermen, the Coast Guard Auxiliary, municipal officers, and the state fire marshal, who has the responsibility to address this issue, we've looked at many possibilities and found them too costly and unrealistic. The proposal before you in providing a new and needed solution is the outcome of that cooperative effort. This proposal includes providing up-to-date education for flare users, safe collection events, a small fee on the purchase of flares, and use of the best practice disposal method, which is incinerating them at high temperatures in an approved incinerator. Because Maine already had a small incinerator that was purchased for disposal of fireworks, it was bridging the gap while we worked to pass this legislation, which includes funding to purchase a larger incinerator. This need, which I mentioned last session, has become even more urgent. Fire Marshal Thomas has informed me that because of the intense heat emitted by flares by design, their high temperatures, as they're incinerated, damage was being done to the smaller incinerator, and he had to stop using it. Meanwhile, the storage bunkers are getting full. These are life-saving devices. They are required. They need proper disposal. The bill is written to allow outside funding, and while that effort continues, I ask your support so that we can finally put forward the much-needed solution for this problem. Thanks for your attention, and I'm happy to answer any questions. My favorite bill.
It's getting to be mine too. I have Representative Newman, I'm sure has got an interesting question also, and Representative Reckitt. Go ahead, Representative Newman.
Yeah, thank you, Madam Chair. My only question is what's the difference with disposing on the marine flares versus commercial flares that they carry and tractor trailers? I would think that we need to find a way to dispose of those too.
That's a great question, and I don't have the answer for that. Perhaps the fire marshal does. With the this is a supposition, but one thing that has been tried for disposal of flares in general is shipping them out of state, which requires special permits, transportation, extremely high cost, and taking them to another state with big incinerators. I'm guessing that might be what happens, but I agree. We need to have a good disposal system for every flare. I don't think the fire marshal's responsible for the highway flares, however.
A follow-up, please.
Yes, please.
What I would like to do is find out from the fire marshal's office if this is something we could add to this bill, so it would just blanket and consistently be all flares for disposal.
Yeah, I hope the fire marshal's here. He.
Yes, I believe so.
Okay, great. Thank you. Thanks for the question. Yeah. I'm all for it if that's appropriate.
And thank you, Representative Newman. I don't think I've ever heard that question, but thank you.
We did talk about it with the group that's been getting together and decided to focus in on marine flares, but it's a question I had as well, but I don't have the answer.
Okay. Representative Reckett.
Thank you. Representative McCray, I admire you for your persistence and for giving me the opportunity every 2 years to remind people that although they think I'm the persistent pusher of the Equal Rights Amendment, my background is in marine biology and ecology. And so I have been interested in this bill from the start. And I hope that with perhaps with Representative Newman's help and the truckers' help, I mean, they've done some wonderful work on other things. You think that they could come up with, I believe it was like $40,000 was the cost of the disposal unit, which seems to me a minuscule amount to solve this problem. And I think last year we had sort of prayed that appropriations would do that in the end. And then of course, none of that happened. So I'm really a strong advocate of this bill, not only to support my sister legislator who has been possessed of this problem for now 5 years, but I think it really is critically important. I represent a coastal district, and I'm sure there are marine flares in the deserted lobster huts that are down here at the end of my street. I spent a lot of time working on the problems of explosions of propane, et cetera, and natural gas. Well, this is another explosion issue, and I think we're just asking for trouble if we don't finally do something about this. So I really urge the committee to find a way this year. If we have to have a bake sale, for Lord's sakes, let's get rid of the darn flares. So thank you for listening. And if I had a lot of money, I would donate I donated an incinerator, but I don't have it. Thank you very much for listening.
Representative Reckett. Representative Reckett, we could have a GoFund request. So I have Representative Pickett.
Yes, thank you, Madam Chair. Representative, I have to ask you this question. After the work you and I did on it in the last session, are we going to get, this is the question, are we going to get it across the goal line this time?
Well, I'm calling this my white whale bill. I am determined to get this to happen. And as I mentioned, the bill written to allow other sources, and I'm looking at those other sources of funding so that, I mean, as Representative Rickett said, it's an even more dire problem now because the other incinerator is not available to us. So we've got to do something. And I think this is we looked at a lot of solutions. Actually, the fire marshal had a brilliant solution, but it turned out it was federally illegal. So this is what we've gone through a lot, and this is the way to do it. And I really appreciate your support on it, Representative Pickett.
Any other questions? Representative McCray on the added language at 5011 is to impose a fee of 25 cents. That's going to general fund because I don't know of any dedicated revenue, right? So it's got to go to general fund.
Well, unless the committee wanted to make it, that could be an amendment to make it a dedicated fund. It's the way that's coming from the fire marshal to have it go, which would be available still to keep things going. He needs, he'll need to replace this incinerator eventually.
Yeah. Okay. Thank you. All right. So, no other questions? I will then ask, let me see what number I am. I will then ask people to speak up, those who are in favor. And please raise your hand if you are in the other room. We will bring you forward. Okay. Those in favor, I have Edward Matlack, Rebecca Graham, and that's it for now. Is anybody? Rebecca Graham?
I know.
Welcome.
I think she is not here. She was from the Maine Municipal Association, had to go to a legislative policy committee.
Okay. I'm sure we have her testimony. Mr. Metlack, you wish to give us testimony?
Good afternoon. Yes, I do.
Thank you. Go right ahead.
Very good. My name is Edward Matlack. I'm here today to testify in favor or in support of LD 514. I work as a shift master and operate a small motor vessel on my time off, several of them. In 40 years of going to sea, dealing with expired pyrotechnics has continued to be a problem. When I started my owning boats, it became an even bigger problem. The pyrotechnics and marine flares have a 3-year lifetime. After expiration date, that's actually printed on each flare, they're no longer acceptable to the U.S. Coast Guard. And as Representative McCray said, you could carry out-of-date ones, but it's really not encouraged, and the Coast Guard certainly won't accept them. They're defined as unsafe to use at that point. The manufacturer won't warranty the things. This question still remains, how do you get rid of them? Having a dedicated incinerator would be a great boon to the state's fishing folk, commercial vessel operators, and pleasure boaters. Without a designated incinerator, they pile up in our barns, our shops, our basements, and apparently at the fire marshal's bunkers somewhere. And they just get more and more unstable the longer they're held. Every documented vessel carries at least 12 flares. The state has, best number I could find was about 7,370 documented vessels. And those 3,440 or thereabouts are working vessels. This works out to about 29,480 out-of-date flares every year. If you figure on replacing a third of them, everybody's about a third of those folks are replacing all their stuff once a year, in a year. It doesn't include boats that are registered elsewhere, but are kept and cared for here in Maine. I strongly support a dedicated incinerator so we can safely dispose of hazardous, outdated marine flares. Thank you for your time, and I look forward to answering any questions.
Those are sobering numbers. Thank you. Any questions for Mr. Matlack? Seeing none. Again, Mr. Matlack, we probably have your testimony in writing, do we?
That is correct.
Great, thank you.
Have a good day.
Good. I read Will Owen. Is that someone here that wishes to speak?
Yes, I am here.
Okay. Are you waiting to come in? Is that what we're
Nope,
waiting?
my video's not working today. I do apologize. If that's okay, just to do it verbally.
Just tell us your resident and what organization.
I'm a resident of the town of Yarmouth, and I'm the president of the Maine Harbor Masters Association. I'm also a full-time harbor master for the town of Yarmouth. We want to support this bill. As a harbor master, I also work certified by the United States Power Squadron to do vessel inspections. And as we require people to update their flares, we get a lot of inquiries on how to dispose of them. The Yarmouth Fire Department does try to assist at times, but we've kind of been overloaded. So we're trying to push away from that. And I get them left on my doorstep constantly because people just don't know what to do with them. And it just kind of creates an issue going forward. So we would very much, as the Maine Harbor Master Association, like to support this bill going forward for a proper way to dispose of flares, seeing as they're required to be updated so often. And that's all I have for this time.
Thank you. Any questions for Mr. Owen? Mr. Owen, as president of Maine Harbor Master Association, you represent all the harbor masters along the coast?
That is correct. We represent all the harbors that have municipal harbor masters throughout the state.
So you've heard this as an issue from them also?
It's we have a yearly conference, and we have, obviously a lot of communications throughout the year. And this is something that comes up every year. And we've actually been reaching out to the fire marshal's office with questions on this. So when this bill came about, this was definitely something we all jumped on board very quickly.
Very good. Thank you very much.
Thank you for your time.
Yes. Anyone else wish to speak in favor? Seeing none. Anyone in opposition to this bill? Not seeing anybody. I will ask anyone wish to speak neither for nor against. And hello, Mr. Thomas.
Hello again, Senator. And
Go
committee
ahead.
members, it seems like we're here again.
I must have missed you. You wanted to speak in favor, did you? So go right ahead. Yes.
I'm actually, my testimony technically is neither for nor against, so I think we're right at the right time anyways, but Senator DeChambeau, Representative Warren, the members of the Criminal Justice and Public Safety Committee, my name is Joe Thomas and I'm the State Fire Marshal. I'm here today to present testimony neither for nor against LD 514, an act to establish and promote a safe system for disposal of expired marine flares. The Office of State Fire Marshal has been involved in the disposal of marine flares as well as other explosive material since 2004. Prior to the presentation of LD 252 and LD 430, an act to improve safety in the disposal of expired marine flares in previous sessions, the Fire Marshal's office could provide this service as we received expired flares in quantities that were manageable for disposal. After this program was more broadly publicized during the previous hearings, the scope of the demand for this service has increased dramatically. At the present time, the State Fire Marshal's office has over 2 tons of expired marine flares awaiting disposal and safely kept in our explosives magazine. However, we are unable to do so until we have acquired the necessary disposal unit capable of incinerating such quantities. Upon experiencing the scope and demand for this disposal service, Fire Marshal's office performed a risk assessment with the Maine Department of Inland Fisheries and Wildlife. IF&W registers approximately 52,600 boats used in tidal waters in and around the state of Maine. The U.S. Coast Guard requires visual distress signals be on board any boat 16 feet or more in length and operating in these tidal waters. State of Maine rules require a minimum of 3 flares if pyrotechnic visual distress signals are used. The useful lifespan for a pyrotechnic flare is 3.5 years. Therefore, we can expect at least 45,677 flares to expire every year. Our existing disposal unit purchased 12 years ago for the incineration of confiscated fireworks that were illegal in the state at the time is designed to dispose of .20 to .50 caliber ammunition and up to 30 pounds of Class C fireworks. If the Office of State Fire Marshal is to continue providing such a disposal service, a larger capacity disposal unit designed specifically for the classifications of explosives contained in marine flares will need to be acquired. The mobile thermal destruction unit designed to handle such a capacity has a cost of $41,500, and funding for such a purchase will be needed. The Office of State Fire Marshal appreciates the importance of the issue the sponsor has raised, and we recognize that regardless of whether legislation is passed or not, the Office of State Fire Marshal is going to be the primary agency conducting these disposal efforts. However, if we are to continue this service, it must be conducted in a safe and efficient manner for personnel safety and the proper equipment acquired. I will be happy to answer any questions and provide any further details if I can.
Anyone have any questions for Mr. Thomas? One moment. I have Representative Newman, followed by Representative Pickett.
Thank you, Madam Chair. I was just wondering if they would have any objection of adding road flares to this legislation. We have a place to at least get rid of the road flares too, without having them thrown in landfills.
Your added materials would need to be studied from a perspective of how much more can I add to the capacity of the level of incinerator that we're looking at. You know, I don't even know what the scope of the problem is as far as motor vehicle flares are concerned. I don't know what that scope is. So I don't know if that's something that we can just take on, given the resources we're asking for, or if it would require, a larger incinerator. I don't know. We can certainly look at it, but for it to come forward right now in conjunction with what we've assessed is needed for the marine flares, I'd be somewhat concerned with that at this present time.
All right, thank you.
Representative Newman, could you, I didn't get the title of those other flares. What did you call those? Traffic?
They're just a road flare or traffic flare. I mean, they're required in most commercial tractor trailers and stuff. If you break down on the side of the road, you'll see them flares out a lot of times.
Good, thank you very much. Representative Pickett, did you bring your hand down? You're all set. I have a few questions. We've been looking at this. I think this is the third year in a row for me anyways. And I do find it interesting in that, there's a need for flares, but it also creates a problem. We seem to be stuck with saying the same thing about this incinerator. And in Ms. McCrae's, Representative McCrae's testimony, even the larger ones have caught fire or have had problems. So a couple of things. Have you looked at other states, especially coastal states, what they might do? And Representative McCray is nodding. Is it just the money aspect that's holding this up, or what?
Can I answer?
I directed that to Mr. Thomas first, and then, yes.
Well, certainly, and Representative McCray and I have jointly canvassed quite a bit of the country for information, and my experience has been everybody else just ignoring it. There are a few places that are trying to address it.
Throwing the rule.
But the scope of what they encounter once they go down this road is almost overwhelming for them. So I do know that many of the folks that we've talked to in the boating industry, they're really looking at us to lead the way on this.
Yeah. Representative McCray, did you want to add to that?
Thank you. And thank you, Fire Marshal Thomas. Nobody has solved it. This is the solution. Everything out there is, as I said, not realistic, expensive, way more expensive than we're talking about. And nobody solved it. Testimony you have it from Boat US, and they're a national organization that's contacting me regularly to say, is it done yet? Is it done yet? Because they're looking at how we can do this. They want to take this and have it go to other states, but no state has solved it. We looked particularly at Florida because they were doing studies, but they haven't solved it either.
I think Representative Newman raised a good question about those road flares and those truckers. If it's interstate, and you don't have to answer this question, but it's in my head that Congress should be getting in on this if they're going interstate. But maybe Mr. Thomas, or I should have asked the harbor master this question. It was stated that each vessel has like 12 of these flares. And I don't know where that number comes from, because you use it when you need it. And it seems there's a large number that are unused, and that's the problem. Can we address that, Mr. Thomas?
Senator, state rules require that if a vessel has pyrotechnic visual flares on board, state rule requires that they have a minimum of 3.
3.
Yeah, and in most cases that Representative McCray and I solicited information from various marine type suppliers. They generally come in packages of 3 or 4, and that seems to meet most of the obligations of requirements in whatever state they're used. But Maine rule does require a minimum of 3.
Thank you. Representative McCray, you were nodding or shaking your head. I don't know which one.
Well, there's a difference between documented boats and not. Mr. Matlack was talking about documented boats. So they are bigger, they require more. Most of the boats we're talking about are the commercial fishing boats, the recreational boats in tidal waters, and they're required to carry 3. And it's not about whether they're used or not. They have to be on board because they're to save your life.
Yeah.
But they expire. So it's the fact that you haven't used them is a good sign. It means you weren't in an emergency. But you have to have them in case you are.
I know. Thank you. You don't want to be out there and say, I should have bought another package. Okay, yeah. Good. I get it. Anybody else? Oh, Representative Pickett, thank you.
Yes, thank you, Madam Chair. So, Mr. Thomas, it seems as though we have the non-funding with the with the incinerator right now. It seems as though where we are is we're almost back to where we were in the beginning, and that is that and you tell me if I'm correct. Why would this not be a unfunded mandate from the federal government on boats, on having these fairs? Because it's the Coast Guard that's that's a federal program that's saying you have to have them and penalizing these fishing boats, correct? So, and the only reason I say that is this: if that is true, then why can't, I don't expect them to do everything, but I think Representative McCray from going on the bill before, she reached out to them and said, hey, how can you help us? How can you give us some help in this? And is the answer still today what it was then? Is, well, so sorry, too bad, figure it out. Is that pretty much what it is?
Representative Pickett, I mean, you're right on. You know, I mean, I was fairly confident the last time we had this laying on the appropriations table when it died, when COVID hit. So, I mean, we were that close to the goal line. You know, and I mean, really, our posture that I'm neither for nor against, you know, it's simply based on the fact that, hey, I'm not creating this problem. But at least we're willing to step up to the plate and try to help take care of it. You know, we have been doing the disposal since 2004. People would call us routinely and say, hey, how do I get rid of these? And I'd send an investigator or inspector down, pick up their bag, and we'd burn it off in the incinerator when we did fireworks. It was no big deal. But now when you look at the scope of this problem, and I'm saying, holy mackerel, you know, and the real reality is, if we're going to do it, and my people are doing this out in the field, I want it to be done safely too. And you know, that was one of the big issues for going to the industrial strength disposal unit. But you know, I mean, as far as I'm concerned, I mean, granted, I do realize, you know, that there's a fire problem and a dangerous problem out here with these things in cellars and garages, everything else. And you know, if you look at what we do and just read the papers, we got a fairly busy mission going on right now with just what our mission is stated to be. But given the fact that nobody else will address this issue, we'll step up to the plate and try to help out here, but we need some support behind this. And to Representative Newman's point about the road flares, you know, sure, that's just another part of the equation. I just don't know right now, based on what we're asking for what was identified in marine flares, if we would really have the capacity to just be able to add another associated hazard resolution to that. I don't know. But I can tell you this much. The Office of State Fire Marshal is manned with people that are good soldiers and will do what we can to try and fix the problem. But philosophically, I just don't think it's really our problem because we didn't create it. The state didn't create it, but we're going to have to fix it. So,
thank you, sir.
Senator Seaway.
Thank you, Madam Chair. I was just thinking out of the box a little bit and was thinking about these biomass incinerators like Farmington has. I mean, it's really an amazing piece of equipment. I didn't know if that would burn them up. What do you think, Commissioner? What do you think? What do you think, Commissioner? Do you think the biomass incinerators would work?
You just elevated into commissioner? Okay.
Well, I mean, yeah, correct.
I have no idea. I have no idea what the capabilities of biomass are. I just don't know.
I mean, they burn pretty hot. It's amazing. So I didn't know if that's something to look at. Maybe if if,
I'm sure we can find out before any work session, so.
yeah,
Thank you. I was going to suggest that. That would be helpful. It's a yes or no question with a phone call.
right.
Thank you.
Thank you.
All right. Anyone else have any questions? Thank you very much. Anyone else wish to speak neither for nor against? Seeing none, I will close the public hearing on LD 514.
Thank you, everybody.
Thank you, Jay. We just like seeing you. Thank you. All right. I now have let me just take a look here. Do we have Senator Baldacci here?
Doesn't look like it.
I don't see him. Anyone here on behalf of Senator Baldacci and his bill, LD 521? Not, I'll skip it right now. Which brings us to
Steve Gordon just raised his hand.
Deb, you had?
Steve Gordon just raised his hand. He's coming into the committee room.
Who is?
Steve Gordon.
He's the head of the county commissioners organization.
And is he going to speak for Senator Baldacci?
We can't. We need a legislator to present a bill.
I know, that's what I'm waiting for.
Hi, everybody. I'm back.
You missed a riveting discussion about flares.
Sorry.
Go to 661.
Yeah, I'm gonna along. I'll try to reach Senator Baldacci. He's
Deb can do that. Let's move to the next bill,
okay.
Senator.
Yeah, Deb could do. Thank you.
You're welcome.
Is Representative Talbot Ross here with us?
No, I need to text her when her bill is up.
Oh, well, then we can probably take Representative Warren's bill.
Okay, and then I'll contact the two legislators.
Representative Warren is ready. Yes.
Absolutely, I'm ready.
Okay.
Sorry.
Well, I must have put your bill aside. Which one is it 477?
Yes, it is, Madam Chair. Thank you.
Thank you. The next bill we're going to review is LD 477, an act to allow for fair restitution by providing that restitution does not include the costs of analysis of suspected illegal drugs, brought to us by Representative Warren.
Thank you, Madam Chair. Senator DeChambeau and honorable members of the Criminal Justice and Public Safety Committee, I am pleased to present to you today LD 477, an act to allow for fair restitution by providing that restitution does not include the cost of analysis of suspected illegal drugs. The bill is simple. It proposes the removal of 9 words, and I quote, "and the cost of analysis of suspected illegal drugs" from our restitution statute. The genesis of this bill was a criminal law advisory commission meeting that I attended last year. When discussing that this analysis, the suspected illicit drugs analysis, was included in restitution, one CLAC member exclaimed, "It feels to me like the government assassinating a prisoner and then sending a bill to the family for the price of the bullet." He sure got my attention. So I started doing some research. And it turns out that the CLAC member was referring to something that I didn't know existed historically, referred to as the bullet fee, a financial charge levied on the family of executed prisoners. And in my testimony, I've included a link if you want to learn a little more about the bullet fee. Now, you might be tempted to think that this provision was added into our criminal code because the state was spending so much money on the testing of suspected illegal drugs. Was the cost of this testing breaking the proverbial bank? Had a problem been identified and been brought to the legislature in search of a solution? So my research continued, and I got the legislative folder for this proposal from our legislative law library. And I've included the entire folder with my testimony because it wasn't that large. The bill started off as an act to improve sentencing for serious offenders. It was proposed in 2005, and the original proposal authorized the court to revoke probation for crime committed by an inmate, made other changes regarding made other changes regarding the sentencing for inmates who committed crimes, expanded the definition of increased sentencing for crimes against law enforcement officers, and proposed an expansion of the restitution definition by including this critical investigation expenses. The bill was pared down, as you can see from the attachment to my testimony. The bill was pared down to eliminate every other provision, and the only thing that remained was the expansion of the restitution statutes to include these investigation expenses. Interestingly, though, there is no testimony in favor of this particular provision included in the legislative record. But importantly, there was opposition to the idea of collecting restitution to be paid to a state agency. As we all know, restitution is for victims. We should not be collecting restitution to pay state agencies. This bill again removes 9 words, "and the cost of analysis of suspected illegal drugs" from our restitution statute. Maine citizens already pay for our state agencies through their numerous taxes. I'll say that again. All of us and all Maine citizens already pay for our state agencies through their numerous taxes. We should not be charging the accused an additional tax for their own prosecution. I ask that you vote ought not to pass on this bill, and I'm happy to answer any questions you might have for me.
Yes, thank you. Any questions for Representative Warren? I see Ms. Overton.
I wouldn't ask, but Representative Warren, you just asked the committee to vote ought not to pass on your bill.
Oh, sorry. I'm distracted by my 2 little dogs, Tissue and Tank. I hope the committee understands I'd like you to vote for my bill. Please vote ought to pass. I'm sorry.
Well, that's why it was a pregnant pause on my behalf. I said, did I just hear right? Okay.
Sorry.
You are asking us to pass your bill. Thank you.
Please, and Tissue and Tank would like you to pass it as well.
I was just going to ask you which one wanted you not to pass.
I'm sorry, guys.
Anyone wish to ask Representative Warren a question about this bill? Seeing none, I will ask who is interested in submitting testimony in favor. And I have 3 people here, 2 in favor. I have Michael Cabetta and Walter McKee. Oh, there's Michael. Go right ahead, Mr. Cabetta.
Senator DeChambeau, Representative Warren, and distinguished members of the committee, good afternoon. My name is Michael Cabetta, and I'm Policy Counsel for the ACLU of Maine. And on behalf of our members, I urge you to support LD 477. Asking the defendant to pay for the cost of their own punishment is fundamentally inconsistent with the basic structure of a just legal system. In some cases, it adds insult to injury. Before our Constitution, inquisitors in the English Star Chamber forced defendants to prove the government's case with their own resources and testimony. Thankfully, as the US Supreme Court wrote 2 years ago, the statute abolishing the Star Chamber in 1641 specifically prohibited any court thereafter from levying excessive fines. Under the American system, the government bears the burden of proving their case and may expend investigative resources on the people's behalf if the pursuit of justice so requires. The alternative, where defendants pay for their own punishment, is cruel and inherently unfair. If the crime is proven, the defendant may be required to make victims or survivors whole through some form of payment. This is wholly different from being forced to pay for one's own drug tests. In Lagos versus the United States Supreme Court unanimously held that defendants cannot be forced to pay for investigative resources under the Mandatory Victims Restitution Act, which requires defendants to repay every penny they are judged to have stolen. The same Supreme Court, if given a chance, might very well hold that Maine's restitution law is similarly invalid. Additionally, supporting this bill would help overcome the opioid epidemic in a small but meaningful way. With so much attention directed to overcoming the current pandemic, it's sometimes forgotten that Maine also faces another deadly pandemic, the opioid overdose epidemic. More than 500 Mainers died from the opioid crisis last year. Because many of the symptoms associated with substance use disorders are criminalized, many people find themselves trapped in the criminal legal system while at the same time trying to navigate treatment for a disability. Imposing criminal fines for the costs of drug testing adds yet more stigma to substance use disorders and contradicts the state goal to encourage treatment and rehabilitation. Because this bill would partially repeal an unjust and unfair law, we urge you to vote ought to pass. I am happy to try to answer questions. Thank you all for listening.
Anyone have any questions for Mr. Cabetta? Mr. Cabetta, I probably will ask you this, but I'm also thinking I could ask Mr. McKee, who's a defense attorney, this question. Do you know how often, or does this happen all the time? Are there numbers of how many times restitution has been asked?
I don't have the numbers off the top of my head. I could try to get them for the work session, but Walt McKee might have the answer.
Yeah, thank you. Thank you very much. Anybody else? Seeing none. The next person that may want to speak is Mr. McKee. Oh, no, wait a minute. Yes, Walter McKee. Are you available, Mr. McKee? Or Attorney McKee? Has he left us? Okay. I will then ask anybody else wish to speak in favor? Seeing none, I will ask anybody opposed to this. Seeing none. And anyone wish to speak and take the position neither for nor against this bill? I have Mr. Pelletier's name. Is he still with us?
He is not in the attendee room.
Okay, thank you. So unless anybody else had, I just wanted numbers, or even if maybe it's an anecdote, I'm not sure. So if Ms. Orbiton can check that, thank you very much. So I will close the meeting of 477. And we only have 2 left, which is, unless about the county and municipal jail standards, if the senator is not here, we'll go if Ms. Talbot Ross is Representative Talbot Ross with us.
Not yet. I sent her a text, but haven't heard back yet.
Madam Chair?
Who's okay? Representative Pickett.
Yes, ma'am. I don't mind waiting a little bit, but if neither sponsor is able to be here within a reasonable amount of time, we probably should just put these hearings on another day if they're not able to be here.
Yeah.
Thank you.
Thank you, Representative Pickett. We have text them.
So Deb, sometimes what we do is call clerk to clerk. Senator Baldacci chairs state and local. Should we see if that's where he is?
Will do.
Madam Chair?
Yes, Representative Pickett.
Since we're waiting, could we take about a 5-minute break so I can have a quick side caucus with my group?
It is now, how about 2:45?
Sounds good. Thank you.
Go ahead.
Senator? Rachel Talbot Ross is in the room.
Thank you. We'll now wait till everybody else comes. Rachel, or Representative Talbot Ross, the Republicans asked to have a little caucus till 15:15. So.
Oh, okay. I'll just, thank you, Senator. I'll hang out and just turn my video off until you're ready.
Okie doke. Thank you.
Thanks.
Oh, God, I'm tired. You know, Representative Lookner, we've been talking about those flares and the cost of incinerators for years. I'm wondering why that isn't in a budget to buy instead of having a bake sale, you know? So.
Yeah, that seems like when we did those LD 242 or whatever it was with the training facilities, like we could, you know, bond to something like that.
When we're all together, a Representative Talbot Ross is available.
We've got all but one member in the room, so we're okay to start anytime.
Well, I've got 1 minute. I'm waiting.
Yep.
You made it under the wire, Representative Warren. Okay. We shall begin. The next bill we have before us is LD 661, an act to ensure equity. Is that the one? Yes. An act to ensure equity in petitions for rulemaking under the Maine Administrative Procedure Act. And the sponsor is a Representative Talbot Ross, and she's with us. Good afternoon.
Good afternoon, Senator. Yes,
go ahead.
It's great to see everyone once again. I hope you're enjoying a good day. Senator DeChambeau, Representative Warren, and the honorable members of the Criminal Justice and Public Safety Committee. My name is Rachel Talbot Ross. I represent House District 40, which comprises the Portland neighborhoods of Parkside, Bayside, East Bayside, Oakdale, and the University of Southern Maine campus. I want to thank you for the opportunity to come before you today to present LD 661, an act to ensure equity in petitions for rulemaking under the Maine Administrative Procedure Act. The goal of this bill is to guarantee fair, equitable, and non-discriminatory access to our rulemaking petitions. The Maine Administrative Procedure Act, or APA, requires 150 registered voters in order to petition a department for rulemaking. This statute may be reasonable for the general public, but for many residents of our state correctional facilities, this means that access to the petition process is not available. Specifically, women in Maine's correctional facilities are currently shut out of the process. None of Maine's state correctional facilities house 150 women. In fact, there are not 150 women in the entire Maine Department of Corrections system, thank God. And there is no one facility with the capacity for 150 women, thank God. However, unintentional, this means this group of women are effectively unable to petition for rulemaking because of their gender. LD 661 seeks to resolve the problem by allowing 25% of any population or 150 individuals, whichever is less, from a single facility to initiate rulemaking by petition. I'll just say that again. LD 661 seeks to resolve the problem by allowing 25% of any population or 150 individuals, whichever is less, to facilitate rulemaking by petition. This bill does not seek to change the rulemaking process broadly for any other part of the APA. It does ensure that all Mainers, regardless of incarceration at the state level, have access to this fundamental process for engagement with their government. I understand that the Maine Department of Corrections is here today in support of the bill and will offer a friendly amendment. I support their proposal, and I'm glad to work with the department and the committee to advance this measure. I want to thank you for your time, your attention, and all of your consideration for this measure, and I'd be happy to take any of your questions.
Thank you. Any questions for Representative Talbot Ross? Seeing none, we'll continue and proceed with anyone wishing to speak in favor of LD 661. I have the Department of Corrections, either Commissioner Liberty or Anna Black. Welcome, Commissioner Liberty. Do you wish to speak in favor?
I do. Thank you, Madam Chair. Senator DeChambeau, Representative Warren, and distinguished members of the Criminal Justice and Public Safety Committee, I'm Randall Liberty, the Commissioner of Maine Department of Corrections. LD 661 addresses an issue of equity between male and female residents interested in initiating the rulemaking process. The MDOC agrees with Assistant Majority Leader Talbot Ross that the current process for residents at the MDOC to initiate rulemaking is unfair to female residents due to the currently low number of female residents incarcerated in Maine. Good problem to have. Currently, the statute requires that the agency shall initiate rulemaking procedures when a petition is submitted by 150 or more registered voters of Maine, with the signatures verified by municipal clerks through voter rolls. While it may seem cumbersome for male residents of MDOC facilities to gather 150 such signatures, it is possible for them to do. All male MDOC residents and facilities have more than 150 residents, and many MDOC male facilities have more than double the number of residents, whereas there are currently only 167 females in DOC custody. Individuals incarcerated have a particular interest in MDOC rules because those rules may govern many of the issues most important to them, including religious services, disciplinary violations and disciplinary processes, furloughs, work release, and supervised community confinement, and the grievance process. The bill does not require the individuals signing the petition to be registered voters and proposes allowing for only a 25% alternative to the number of 150. The addition of this 25% alternative would ensure that female population is able to acquire signatures within their facility and not be disadvantaged by having small numbers of incarcerated women. The amendment MDOC proposes as in verification as reasonable of signatures of the individuals who sign a petition. It provides that rulemaking is not required if there is either petition about the rule within the past year and the MDOC is not forced into unnecessary repetitive rulemaking. It also separates out into two statutory provisions that the process for those in custody in the jails and those in custody of MDOC corrections, so that the jail residents cannot petition the MDOC for revision of anything but jail standards, since only those standards govern their confinement. The following proposed amendment has been shared with the sponsor. Notwithstanding subsection 3, the Department of Corrections shall initiate appropriate rulemaking proceedings within 60 days after receipt of a petition or adopt or modify a rule submitted by 150 or more persons incarcerated in a department facility, or 25% or more of the total number of males or females incarcerated in that facility, whichever is fewer. Except the department is not required to initiate rulemaking if an earlier petition to adopt or modify the rule pursuant to the subsection was received within the prior year. The department may take reasonable steps to ensure that each signature in the signature of the is the signature of the person whose name it purports to be, and the person was incarcerated in the facility at the time of the signing. The next friendly amendment we'd like to suggest regards county or municipal detention. Notwithstanding subsection 3, the Department of Corrections shall initiate appropriate rulemaking procedures with respect to the standards adopted pursuant to Title 34A, Section 1208 or subsection 1208B within 60 days after receipt of a petition to adopt or modify the standards submitted by 150 or more persons incarcerated in a county or municipal detention facility in the state, or by 25% or more of the total number of males or females incarcerated in a county or municipal detention facility in the state, whichever is fewer, except that the department is not required to initiate rulemaking in an earlier petition to adopt or modify the standard pursuant in the subsection was received within the prior year. The department may make reasonable steps to ensure that each signature in the signature of the person is who it purports to be, and the person was incarcerated in the facility at the time of the signing. That concludes my testimony, and we're glad to support Representative Rachel Talbot Ross in this effort. Thank you.
Thank you. I have Representative Pickett. You have a question?
Thank you, Madam Chair. Commissioner, question on the last one you made, section 2, dealing with the Department of Corrections and the county and municipal detention facilities. Have you spoken to them about this amendment? And I see that somebody is on here, so maybe they'll be able to answer it. But do you have any sense of whether they're in agreement with this or not?
I am not, Representative, I am not sure if they've been spoken to or not.
Okay, thank you.
Anyone else? Commissioner, I'm looking at MRSA 58055. And the way this bill is written, again, that great word, notwithstanding, section 3. Oh, maybe I'm answering my own question. The underline on this bill says the Department of Corrections shall initiate appropriate rulemaking proceedings within 60 days after the receipt of the petition to amend or modify. So it's either amend or modify a rule. What I'm looking at, it also says within 60 days of the receipt of the petition shall either notify the petition in writing of its denial, stating the reasons therefore, or initiate appropriate rulemaking. So someone, correct me if I'm wrong, this one does not say it denial and to be given 60 days notice of, it reads like there will never be a denial of a petition. Does anybody read that differently? So if I'm wrong, I'm asking maybe Jane Overton, if I'm reading MRSA 8055. That's what I was reading. That within 60 days after the receipt of the petition, you shall either notify them in writing of its denial, if there is one, therefore stating the reasons therefore, or you will initiate rulemaking process. So that's my question.
I'm happy to look into that for work session.
Okay. Thank you. Anyone else? Thank you. Thank you, Commissioner.
Madam Chair.
Yep. I have Michael Cabetta. I think he's testifying on all of these so I can pronounce his name correctly. And Susan, oh no, I have Suzanne Rudalevich.
Senator
Mr. Cabetta, go ahead.
Thank you. You've pronounced my name correctly, so I should stop testifying. But Representative Warren, distinguished members of the committee, hello again. My name is Michael Cabetta, pronounced correctly by Senator DeChambeau, and I am Policy Counsel for the ACLU of Maine. On behalf of our members, we urge you to support LD 661 and thank Assistant Majority Leader Talbot Ross for bringing this very important bill forward. Current Maine law allows for anyone to request changes to administrative rules. If 150 registered voters request a rule change, the state must initiate rulemaking. This is as true in prisons as in other systems. As the committee knows, prisons for men have incarcerated populations of well over 150. But the number of women between the Women's Center and the Southern Maine Reentry Center combined was 126 as of yesterday, according to the Department of Corrections website. What this means is that in practice, these numbers disenfranchise women and give them less power to shape their conditions than incarcerated men do. The bill that Assistant Majority Leader Talbot Ross put forward would solve that problem. You've already heard what it does, so I won't repeat it. Incarcerated people are wiser than anyone else about prison conditions. This bill would help transform that wisdom into better governance. We urge you to vote to pass. And I'm happy to try to answer any questions.
Any questions from anyone? Mr. Cabetta? Seeing none, again, thank you. Suzanne Rudalevich? Do we know if she's here?
She wrote in the chat to take her off the live testimony list.
Okay, thank you. Therefore, anyone else wishing to speak in favor? I will go to anyone wishing to speak in opposition. Sheriff Trafton, yes, hi there.
Hi.
Yes, you may make your presentation, your testimony, please.
Thank you. Thank you. My name is Jeff Trafton. Well, Senator DeChambeau, Representative Warren, and esteemed members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Jeff Trafton. I'm the Sheriff of Waldo County, and I'm here today on behalf of the Maine Sheriff's Association. Maine Sheriffs met to discuss this bill, and our unanimous position is to oppose LD 661. The Maine Sheriff's Association Legislative Policy Committee reviewed the bill. While recognizing the motivation of the sponsor of this bill is to establish equity among incarcerated individuals, LD 661 would implement a one-size-fits-all solution that would assuredly result in unintended consequences. As written, 3 women housed in the Knox County Jail could make sweeping and costly changes to amend or modify the rules at the Knox County Jail, as their average female population hovers around 10. While it may seem far-fetched, would a petition for Taco Tuesday be put into the process for proceedings? If Piscataqua County had just 2 inmates of their 5 women decide to petition the jail for costly changes, this bill would mandate the demands be considered. In Franklin County, just 1 inmate of the 2 women or 4 men could put forth a petition demanding time and attention of the staff. Maine's 15 jails have consistently delivered exemplary ratings for the services we provide to those who find themselves within our communities, earning significant ratings from the MDOC inspections. We strive to offer ethical and humane conditions that are respectful of our inmates. We collectively seek ways to reduce recidivism and provide inmates with tools to help them succeed upon release. Maine sheriffs, like the sponsor of this bill, expect to establish equity among our inmates, forcing county sheriffs, forcing counties to implement this wide sweeping mandate, essentially adding to the already short-staffed and underpaid corrections staff, can only further our challenges with finding qualified staff to support our facilities. As many distinguished members around the virtual horseshoe know, Maine sheriffs are closely aligned with this committee, and we value those relationships. We strongly urge this committee to recognize the potential damage of LD 661 and unanimously vote ought not to pass. Thank you for your consideration. I would be pleased to answer any questions you might have.
Thank you, Sheriff Trafton. I have Representative Warren followed by Representative Morales.
Thank you, Madam Chair. Welcome, Sheriff. Good to see you. I may be misunderstanding. I'm either misunderstanding your testimony or I'm misunderstanding the bill. Isn't the petition to ask for a rulemaking process? So what I'm saying is, I don't think that this creates the ability for the, I think you said 3 women inmates at the county jail to force a Taco Tuesday on anyone. I think this just says, sorry, I think it just says that they will petition for the rulemaking process, maybe for Taco Tuesday, but more likely for something more important than that.
Well, I agree with you on that. I think I'm not sure if the group misunderstood that when we were putting the testimony together, but I can go back to the MSA and clarify that for you.
That would be great if you could do that before the work session, because you may not be in fact opposed to it. I really think it's just saying that they could ask for a rulemaking process, which my assumption of you all is that of course you would want them to have the ability to ask for a rulemaking process. So I think somebody misunderstood the bill. So that would be great before the work session, Sheriff. Thank you.
Thank you.
Representative Pickett.
Yes, thank you, Madam Chair. Yes, Sheriff Trafton. Real quick question from the MSA's standpoint. I just wanted to find out. I'll ask you the same question. Did you folks try to reach out to the DOC, or maybe I'll go back a little bit. When did you find out that about this bill, about what this was going to do? How long ago?
I don't have the answer to that question, Representative Pickett, but I check with the MSA and I can get back to you on that.
Okay, because my question is, is that if you've known about it for a while and had enough time to talk about it, I'm not sure if you talked about it last week, the week before, whatever. I just want to find out if there was any attempt to have communication with the commissioner, because I really think it's really important on these things, all of these things like this, when it involves the two you folks in the DOC together. It's important for you guys to be having a conversation amongst each other, even if you don't fall on the same side, a conversation with each other to know what's coming up, so that you at least are aware of it. So that's my only concern here. I just want to make sure that you guys are talking with each other when these kind of things are coming up. Thank you.
Thanks.
Representative Morales, you were.
No, I was going to clarify the same point that Representative Warren discussed.
Okay. Thank you. Yes, I find 4 words a little problematic. It begins with the Department of Corrections, and we all know about rulemaking in the state agency and the Department of Corrections. I don't know if the same rulemaking applies to county or municipal detention. We're talking municipal detention. That I just question whether our arm can reach that far. But that's maybe because it's late in the day and I'm thinking a little weird, but so I want that clarified, if we can even do that. And also, if the county was able to do that, what is the role of the Department of Corrections? It's not really a standard. Sheriff Stratton, I'm just babbling on that. Did you have a comment to make on that?
Well, I may not be as up on that as I should be. I know we do have a fair amount of jail standards that we report to the MDOC, and they grade us on those or rank us on those. But whether or not it applies to a situation like this, I'm not exactly sure. I'd have to check on that further.
Okay, thank you. Anyone else have any questions? Comment? Thank you. Anyone else wish to speak in opposition of this bill? Seeing none. Anyone wish to speak neither for nor against? Seeing none. Wish we could tell you when we're going to have a work session, but we will tell you when we know. So that's what it is for now. I will close this hearing on LD 661. And
thank you, Senator.
Thank you, Representative.
Thank you all.
Does that conclude for the day?
No, one more, and Senator Baldacci is here, and let's make it snappy.
Okay. I think we've been doing quite well, Representative Warren.
Well, we're straying a little bit into work session territory, so.
Yeah, and I think I won't accuse you of doing that at all, Representative.
No, definitely not.
Okay. Can you give me that number, please?
521, and Senator Baldacci is here. Welcome, Senator.
Welcome. Thank you for having me. I've been in the waiting room. No, I've been bouncing around to 3 or 4 different committees, but thank you for the notification to come back here.
Absolutely.
Senator Baldacci, let me just for the public make the title.
Senator DeChambeau, you can say anything you want.
I know that about you. Okay, LD 521, An act to modify the rule. No, I got that wrong. No, it isn't. And another rulemaking, sorry, an act to modify the rulemaking process for establishing county and municipal jail standards. That probably answers my other question. Welcome, Senator Baldacci, and you may present your bill.
Thank you. Thank you, Chair DeChambeau and Chair Warren, and distinguished members of the Criminal Justice and Public Safety Committee. Thank you for having me. I know it's been a long day for all of us. So let me just, this was requested for me to submit by the County Commissioners Association of Maine. I understand there's some concerns about it, but the primary reason why I wanted to submit it is because we are all aware really of the history of funding and lack of funding for our county jails. They were straitjacketed for most of the last 4 or 5 years in terms of funding. This rule is just to establish or tighten up certain standards. Standards adopted pursuant to this subsection must be evidence-based, minimize the imposition of additional costs, and reflect best practices for the operation and administration of jails. I think that the major concern obviously is the counties want to have not only some say, but also want to make sure that the factor of costs is fully recognized by the state rulemaking. We, as many representatives and senators know, there's a number of unfunded mandates upon localities, upon counties. Counties are doing a lot of work, as you've probably heard. They're doing a lot of work in terms of mental health care, in terms of housing, in terms of trying to do all the different functions that they've been given. Unfortunately, they, obviously, as we've talked about, they shouldn't be the first resort for mental health care. Those should be in hospitals and outpatient settings. But they have to handle a lot, and we want to make sure that the state rulemaking recognizes the fact that costs are burdened on the county taxpayers, which is primarily the residential homes in each county. In Penobscot County, the city of Bangor pays 25% of the entire county budget. So it's millions of dollars each year from homeowners in Bangor to support the counties. And I think it's important that the imposition of costs be a factor that's more fully recognized, if only to make sure that policymakers at the state level are either looking into ways to minimize the costs or to provide additional funding to the counties to do what the state wants them to do. So essentially, the bill amends the laws governing the authority of the Commissioner of Corrections to establish standards for municipal and county jails and detention facilities. The bill requires that such standards be adopted through the major substantive rulemaking process set forth in the Maine Administrative Procedures Act. And the bill requires that the standards for county and municipal jails and detention facilities be evidence-based, minimize the imposition of additional costs, and reflect best practices. Happy to answer any questions. I think most of the substantive or detailed questions I think can be answered by representatives of the County Commissioner Association and others, but I'm happy to answer any questions that I can at this point.
Thank you. Thank you, Senator. Any questions for Senator Baldacci? Seeing none? Okay, thank you.
Thank you. Appreciate your time.
I have those who wish to speak in favor of this bill. I have Sheriff Trafton and also Steve Gordon of the Commissioners Association. Either of you are available and wish to give testimony?
Madam Chair, I'm gonna head out to another committee, but I want to thank everybody, and I will check back later with people if there are additional questions. Thank you.
Thank you. Steve Gordon.
Yes.
Welcome.
Welcome.
Please tell us your name, who and where you're from, and who you represent.
Well, thank you very much, Senator DeChambeau and Representative Warren, members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Steve Gordon, and in addition to serving as chair of the Board of Commissioners for Cumberland County, I'm presenting today as my role of the board president of the Maine County Commissioners Association, and we represent 15 of the 16 counties. We appreciate the opportunity to provide testimony to the committee in support of LD 521. Our position is, first, and I should say this very much so because he has helped us. Many thanks to Senator Baldacci for working with us to bring forward this proposed legislation. Second, we believe the bill itself reflects reasonable guidelines for the Commissioner of Corrections to follow when instituting new standards with regards to the treatment of incarcerates. And let me explain what I mean. Under the current law, the Commissioner of Correction has broad discretion to adopt standards for county jails under the identified Maine statute, and the numbers are there. And it says, the Commissioner shall establish both mandatory and desirable standards for all county and municipal detention facilities, setting forth requirements for maintaining safe, healthful, and secure facilities. Other than this text, there is no further guidance in the Maine statutes relating to the Commissioner's authority. Given the apparent absence of procedural guidelines for the department to set jail standards, the MCCA felt it was important to bring these issues before the legislature. In particular, the essence of LD 521 is to provide reasonable legislative guidelines regarding the Commissioner's authority to establish county jail standards. Now, why is that? The 2020 rulemaking of DOC is illustrative. The absence of guidelines became apparent when this fall the Department of Corrections commenced a rulemaking that imposed new health standards on county jails, many of which reflected issues that came forth in the 129th legislature as bills to this committee. Had these issues not been cut short by the early adjournment of the legislature last year, the legislature would have considered these standards in light of needs and costs. I repeat, the legislature would have considered these standards in light of needs and cost. More specifically, the legislature would have considered whether or not the new standards imposed additional costs on local government, and if so, then would have required a mandate preamble. On the other hand, when left to rulemaking within the Department of Correction, it is less clear as to what procedures, if any, are required of the department when considering new standards and their additional costs. As to the department's recent rulemaking, MCCA has no philosophical opposition to the common services related to women's health and to substance abuse treatment, which in fact are services that are provided within the county jail. Rather, we expressed concern to the department at the time that the new standards were vague and lacked definition. Thus, depending on how interpreted, could result in additional new services and costs for county jails ranging from $400,000 to over $2 million a year, which funds are not available to counties under current Maine law.
Commissioner Gordon?
Yes.
We'll let Representative Warren.
Well, you are quite over your 3 minutes, so could you wrap up? And you know, Commissioner, that we will read the testimony you've submitted, obviously, but give us the nugget. What do you need us to know?
Okay. In essence, this is the essence of LD 521, and it's an inclusion of cost-based standards and of substantive rulemaking process, which will bring the Maine legislature directly into the conversation to relieve counties of these expenditure limitations when implementing new jail requirements. That's essentially the issue. And the conclusion is, we hope certainly that the committee will consider it and report out an ought to pass. And I'm sorry for going over, but we had a lot of information that we wanted to get to you as they were examples, and we thought was important. There was the whole issue of And as you remember, in January, I reported out about being the public service of last resort. Then we have the cap of LD1, but counties have a cap of a tax cap for jails that doesn't allow any variation. LD1, the controlling entity, can vote to the public that they're going to surpass it, not the jail cap. That's a hard cap. With that, I'll stop. Thank you.
Any other questions of Mr. Gordon? Mr. Gordon, you gave as an example last year when the Department of Corrections initiated and presented what last year or last fall was, I would have thought under emergency executive orders to be able to do that is my guess. Prior or in normal times when it wasn't a pandemic, did the Department of Corrections consult with commissioners or sheriffs before instituting rulemaking or any rules?
Yes. I mean, I give the commissioner credit. He did talk to us. And the other example I have is that the department has a county and municipal detention facility advisory committee. And both groups to a person declined to support the proposals.
All right. Thank you. Thank you. No other questions?
Senator, you have two members raising their hands, Representative Pickett. And
I didn't see. Thank you. I didn't see that. Senator Samway, followed by Representative Pickett.
Thank you, Madam Chair. Just wanted to ask Steve Gordon, you had mentioned that the counties couldn't raise the cap. Kennebec County, I thought, raised their cap from 11 to 14% this last fall. So I don't know how they did that if you're not able to.
Well, let me humbly say this. The law says there's a 4% tax cap on increase in costs in a county jail. If a county has surpassed that, I would suspect they're in violation of that requirement.
Thank you.
Representative Pickett.
Yes, thank you, Madam Chair. So, Mr. Gordon, the nuts and bolts of your testimony virtually, as I read it, as I've gone through it, all fall in the third page, first paragraph. Would that be correct?
Well, let me get that. First paragraph.
First paragraph, page 3.
The state limits the ability of the counties?
Yeah, where it says, what does this mean in practical terms? Because most counties are at or near these statutory spending caps, and any new requirements on a jail requires more local expenditures. Cannot be implemented without reducing or eliminating some other cost or service. It's that simple. Otherwise, county jails are put in a position of being responsible for services that they simply cannot afford to provide. That's really the crux of what you're saying, isn't it?
That's correct, Representative.
Thank you.
Anyone else have any questions? All right, thank you very much.
Senator, Representative Morales has her hand up.
Okay. Representative Morales.
Yes, thank you. And thank you, Commissioner Gordon. And I appreciate the input you've provided us over these past years, just to really think about budgets and really think about what we're funding. And I'm wondering if you could just give us a sense of the work you're doing with the county commissioners and your budgets. And, I think we've heard a lot about the folks that we're serving in our jails really have great needs that jails can't serve them with. But that burden, and I often feel that, at the legislature, that burden, we've given that burden to you, to counties, And it's sort of an unfunded mandate on our part of the state of making laws that then imprison people who really need something other than jail. And I'm wondering what the discussions are with county commissioners around the state. There's a little bit of bigger picture about this, but it ties into, I think, your overall points.
I just want to remind folks that we want to keep our questions this afternoon to clarifying questions about the proposals, and we'll do that kind of analysis, Representative, at a work session.
All right.
Thank you.
Thank you for the question.
Anyone else wish to ask a question? Emphasis on ask. Okay, thank you. Anyone else wish to speak in favor of this bill? Oh, yes, Sheriff Trafton, let's not forget you. Go ahead.
Thank you. Senator DeChambeau, Representative Warren, and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Jeff Trafton. I am the Sheriff of Waldo County, and I'm here today on behalf of the Maine Sheriff's Association. The Maine Sheriffs met to discuss this bill, and our position is to support LD 251. I'd like to begin by recognizing the positive communication and collaboration that is ongoing between the Maine Sheriffs and the Maine Department of Corrections. Commissioner Liberty and Deputy Director Dr. Ryan Thornell have encouraged a team effort approach to battling COVID-19 in our county facilities. We've been included in daily communications throughout the pandemic, and the ongoing support has been significant. LD 521 did not originate from the sheriffs, but we understand and wish to speak to events that were instrumental in the creation of this bill. Title 34A, subsection 1208, mandates that the commissioner shall create and maintain a county and municipal detention facility advisory committee. As identified members of this committee, Maine sheriffs have actively contributed to the dialogue and strategizing efforts of the group. The commissioner is further mandated to consult the committee when promulgating standards. MDOC and the commissioner have faithfully adhered to this mandate. Maine statute has become less concise. The recent passage of rulemaking by the MDOC initiated the potential for increased cost to some of our county facilities. Other rulemaking established changes that we believe were not evidence-based practices. We believe the motivation of LD 521 is to remove the ambiguity currently in statute and provide specific guidelines that best meet the needs of all stakeholders of Maine's correctional facilities. Maine Sheriffs ask that you support LD 521 by voting ought to pass. Thank you for your consideration. I'd be pleased to answer any questions.
Thank you, Sheriff Trafton. Any questions of Sheriff Trafton? Seeing none, thank you. Anyone else wish to speak in support of this bill? Seeing none. Anyone wish to speak in against, in opposition to this bill? And it told me I had hands raised and I don't see them. Okay. No one in opposition. Anyone wish to testify neither for nor against this bill?
There's a number of people coming over to speak in opposition.
Okay, there. So, all right. You have, so Mr. Lehman, you wish to speak also, and Mr. Hayden?
Yes,
Okay.
yes, Hayden.
All right, so, and Randall, the first one I saw was Mr. Hayden, Mr. Lehman, and Commissioner, may I hold you for last? Okay, thank you. Mr. Hayden, please.
Thank you, Senator DeChambeau, Representative Warren, distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. Good afternoon. My name is Zachary Hayden. I am Chief Counsel at the American Civil Liberties Union of Maine. I am Michael Cabede's taller, older colleague. We are a statewide organization committed to defending the rights of the people of Maine. And I'm here to testify in opposition to LD 521 because we believe it would undermine the protection of the health and safety of people incarcerated in Maine's jails, and also because we believe it's unnecessary. As background, it's worth noting that the commissioner of the Maine Department of Corrections, who is, I believe, here with us today, is obligated to establish both mandatory and desirable standards for all county and municipal facilities to ensure that the facilities are safe, healthful, and secure. But despite the mandatory nature of this statutory command, commissioners in the past have been reluctant to adopt such standards. And we want to begin just by applauding Commissioner Liberty for the recent efforts to adopt standards governing the use of force, access to medical treatment for people with substance use disorders, and access to pregnancy-related care. As a result of our communication at the ACLU of Maine with people who are incarcerated, we know that additional regulation and oversight of conditions in our county jails is much needed and to comply with statute and to comply with the Constitution. We have sometimes brought lawsuits about some of the issues that are brought to our attention, but I think we can all agree that regulation by ACLU litigation is not the most efficient, effective way to have oversight, and that we think that having rules and standards that are created and enforced by the Department of Corrections is a much better way to go. I want to just take issue with something I heard earlier. The law does not allow the commissioner or the Department of Corrections to adopt any standards, health or safety standards that he may like. The statute says that those rules have to be adopted pursuant to the Maine Administrative Procedures Act. And even though those rules are currently characterized as routine technical rules, there are still extensive standards for those rules. And the rules have to go through public notice, a public hearing. Entities like the Maine Sheriff's Association, the county commissioners have an opportunity to provide testimony. As you all know, though, having the right to give testimony, as I am today, does not mean that the testimony is necessarily going to be followed. So, I think we have submitted written testimony, which discusses this matter a little bit more detail, but we just want to conclude by saying that it's important that the DOC be able to adopt standards. They are to be commended for doing so, and we urge you to vote against this bill, which would make it harder to adopt such standards. And I'm happy to answer any questions.
Thank you very much. Any questions of Mr. Hayden? Seeing none, thank you again.
Thank you.
Mr. Lehman?
Senator DeChambeau, Representative Warren, distinguished members of the committee. My name's Peter Lehman and I live in Thomaston. I'm a formerly incarcerated citizen and a person in long-term recovery. I'm speaking for the Maine Prisoner Advocacy Coalition, and our goal is to promote restorative practices to increase public safety and the health of our community. I'm here today to praise and support the Maine Department of Corrections. Yes, you're welcome. This bill, in short, is an insult to law enforcement and other criminal justice professionals. I don't say that lightly. Before I destroyed my life, I taught future and current criminal justice professionals. I continue to have deep respect for those women and men and their commitment to service, integrity, and professionalism. As their teacher, I knew that they were not perfect. And I certainly knew, and they certainly knew I wasn't either. Nonetheless, they had and still have a commitment to doing it right to the best of their ability. That's why they were there in school, to learn how to do it as professionals. And that's what they learned at the academy: honor, integrity, and professionalism. The current statute calls for the DOC to expound jail standards that are professional best practices. And they go through the process of ordinary rulemaking, which we participated in this year. And contrary to what Mr. Gordon said, the current statute does have standards or criteria. It reads that they must be evidence-based, minimize, and reflect best practices for the operation of and administration of jails. Please notice that the county commissioners really haven't questioned the standards as professional best practices. They only said they want to do it on the cheap. I'm sorry. Integrity on the cheap is not integrity. Honor on the cheap is not honor. And professionalism on the cheap is not professionalism. Of course, we always fall short of our own ideals and can't always do things as well as we aspire to. But the answer is not to discard our aspirations and our ideals, not to hand them over to the money changers. We urge you to vote ought not to pass, and I'd be happy to answer any questions you have.
Thank you, Mr. Lehman. Any questions of Mr. Lehman? Seeing none, thank you again.
Thank you much.
I had to hesitate. I almost called you Representative Liberty, but Commissioner Liberty, go right ahead.
Senator DeChambeau, Representative Warren, and other distinguished members of the Criminal Justice Public Safety Committee. I am still Randall Liberty, and I am still a commissioner. The Maine Department of Corrections opposes this bill for two reasons. First, because it will turn all rulemaking related to jail standards into major substantive rulemaking. As this committee is aware, major substantive rulemaking is a time-consuming and lengthy process that delays the adoption of rules until the legislature is in session. Historically, the process of simply discussing the potential for rulemaking has taken place within the County and Municipal Detention Facility Advisory Committee, a practice that has worked well. Similarly, the technical rulemaking process currently in place is a reasonable procedure for county commissioners, sheriffs, residents of jails, advocates, and victims to dialogue about potential rulemaking. It also it's important to note that technical rulemaking is considered a best practice in modern day corrections, as is the most efficient way to implement fair practices in all facilities. As there are well-worn paths for discussing and initiating rulemaking, this bill begs the question, for what gain? More months will be spent on issues that we have already had ample time via public comments and public hearings associated with the rulemaking process currently in place. The second reason we oppose this bill is the addition of language, minimize the imposition of additional cost. This is vague language that can be interpreted in multiple ways. The DOC makes very seriously the potential fiscal impact of policy and practice changes proposed. Currently, there is ample opportunity for all parties involved to discuss costs during the advisory committee meetings and the rulemaking process. Further, there's already a statutory provision forbidding unfunded mandates. The addition of this vague language may result in a lack of improvement for jail residents, including COVID-19 precautions, medication-assisted treatment for opiate use disorders, and reproductive health care. The Maine Department of Correction remains committed to working with the counties and sheriffs to ensure the needs of jail residents are met in equitable and cost-effective manner. This concludes my testimony. I'm happy to answer questions. Thank you.
Any questions for Commissioner Liberty? Seeing none, again, thank you, Commissioner. Oh, I see, yes. I see Senator Sherway has a question.
Yes, thank you, Madam Chair. Just clarity, I guess Steve Gordon had mentioned about a 4% cap for the sheriff's offices, and seems like this fall it went up 11 to 14% in our area, and my constituents were very concerned about that. Didn't know the explanation, I guess. So what's your take on it, since you was a county sheriff at one time?
Yes, it's been 5 years, so my knowledge may be dated. I'm not certain, but the cap specifically relates to the jails. The county overall budget's not capped, but the county jails are capped at various rates.
Okay, thank you.
Ms. Collins, are you asking to testify in support? Okay. I don't,
In opposition to the bill?
and I'm sorry, in opposition to the bill. Thank you. Go right ahead. Thank you.
Thank you so much. Senator DeChambeau, Representative Warren, and honorable members of the Criminal Justice and Public Safety Committee. My name is Jan Collins, and I'm Assistant Director for Maine Prison Advocacy Coalition, but it is my service on the Board of Visitors for Franklin County Jail that informs my testimony today. First, I am proudly standing with the Department of Corrections in opposition of this bill. While I do hope to honor both Sheriff Trafton and Steve Gordon in my testimony. Both of them spoke to the fact that county jails are suffering under this cap, and I have to affirm to you that that is true. As a Board of Visitor, our last 3 meetings have centered on how we can support the sheriff's budget. In particular, Franklin County has suffered much under this cap. I know that this committee was working on the county jail budgets in the last session, and unfortunately that was interrupted. I was sorry to see that I have not yet seen a bill that would address county budgets. Given that as a fact that county budgets are strained for county jails and sheriff's departments, I think it would be great to address that issue, but I think this bill is the wrong way to address a budget issue. I was part of that hearing on the 7th of November, 2020, where we discussed detention and correctional standards. And for the most part, we supported the Department of Corrections changes, because those changes address things that the courts had already been addressing. Over and over, federal courts have ruled that the denial of medical care to inmates is an infringement of constitutionality, or constitutionally guaranteed rights, and is considered cruel and unusual punishment. Courts have also ruled that women and men should receive equal treatment under the law. All of those things and the substance use disorder decisions made by federal courts support what the department has done. These policy changes directly affected women's health care, substance use disorder, and infectious disease prevention and control programs to address the COVID-19 crisis. There were 30 people present and representing various aspects of county government, all of whom had the opportunity for input into the aforementioned policies. The objections were uniformly against the policy changes only because of cost. So I really feel strongly that it's cost that we should be addressing in a jail budget, but not changes in policy, because the department has done a wonderful job in addressing those changes. I believe this bill is an exercise in futility, as most of the DOC's policy changes involve settled law.
You're at the end of your time, so if you could wrap up, that would be great.
Thank you so much, Representative. I ask you to defeat this bill rather than support evidence-based decision-making. This bill would do the opposite. Thank you. I'm willing to take questions.
Any questions from any of the members? Seeing none, thank you.
Thank you.
Well, this brings a conclusion to LD, I'm going to say it wrong.
521.
521, getting there, thank you, 521. So, thank you very much. This also concludes our meeting for today. I think we're needing to digest a lot of Department of Corrections, or I should say criminal justice, public safety is so involved. We went from marine flares to rulemaking, to assisted living, and some very sad stories. So this is something we all need to think about, and we'll be back. We have, the meeting is scheduled, public hearing this Friday at 10 a.m. There are 3, and I believe there are 3, yes. So we'll see you unless there's any questions or anyone wants to make any last comments. Seeing none, I wish you well. Have a good night.
Thank you. Bye, everyone.